Good morning to the Osceola County Jail. Are you able to, the clerk has advised me that you're not able to see us, although I could see you all.
No, Your Honor, I do not see you. I can hear you, though.
You need to see me. I could see you all. I could see you're wearing a black mask. I don't know, some people want to see me and some people are okay with not seeing me. It's up to you.
I'm fine with not seeing you.
I didn't hear that, sorry.
I'm fine without seeing you, Your Honor. I recognize your voice.
All right, thank you. All right, so counsel for the state who's present, state your name, announce who you represent, and then I'll have the assistant public defender do the same thing.
Daniel Horn for the state of Florida.
Were you able to hear him?
Yes, Your Honor.
All right, excellent. All right, and then counsel for the public defender's office.
Isaiah Romero Sanchez, assistant public defender.
All right, thank you. To those of you who can hear me for initial appearances, when I call your name, come on up to the podium. If you can't afford an attorney, I'll appoint the public defender's office to represent you. We're here to set conditions of release in the case. I'll advise you what the charges are, and then I'll tell you what the conditions of release are. Most of you have conditions of release. If a capias had been issued, I don't have the ability to change the capias amount. If it's a violation of probation, I don't have the ability to change the bond amount. If it's an arrest warrant, I'm required to consider setting conditions of release, even if it's different than what the arrest warrant said. Sometimes, let's see, I'm gonna ask the clerk a question here, but I think I know the answer. You don't have the next court dates, right? No, okay. So, the first case is Daniel Morel Pena. Apparently,
Your Honor, he's a Spanish speaker.
all right. Apparently, there's a button here that I'm supposed to press here. The transfer. Add. Okay, got it. All right. Interpreter. All right. Let's see.
Call. You gotta push the green button to call. Okay. You should come in.
All right. We'll see if this works.
Good morning, Your Honor. This is Carlos Morales, State Certified Spanish Word Interpreter. The interpreter has not been sworn in yet today.
All right. You can remain seated or standing. The clerk will swear you in.
And so I'm just going to translate from English to Spanish to English, the testimony given today.
I do.
Sir, are you Daniel Morel Pena?
¿Es usted Daniel Morel Peña?
Sí, correcto.
Yes, correct.
All right, you have two cases today. One is a case where it's an on-view violation of probation, and the other is a arrest warrant case. We'll talk about it in a moment.
Usted tiene dos casos el día de hoy. Uno de ellos es por incumplimiento del régimen de probatoria y el otro es un arresto por causa de una orden de arresto.
Can you afford an attorney, or do you need me to appoint the public defender's office to represent you?
¿Tiene usted el dinero para poder contratar a un abogado particular o necesita que yo le nombre un defensor público?
Que me nombre un defensor público.
If you could appoint me a public defender.
All right, thank you. The new offense is an allegation of aggravated battery and a child abuse.
El nuevo delito del que se le acusa es de agresión agravada y de maltrato o abuso de un menor.
Pretrial services, does Mr. Morel Pena have any prior criminal history?
Yes, Judge. April of 2020, aggravated battery on a pregnant woman. That was drug battery, which he was adjudicated guilty. I believe he's actually sentenced to probation. He's in custody on that case. Also, he had a contempt of court for violation of no contact. Same victim, Judge. Also, the victim has an injunction in place.
All right, we'll find out if the interpreter was able to get all that.
Sorry, Judge.
No, I'm sorry, Your Honor. The interpreter got the first part, which is aggravated battery, previous aggravated battery, which was
And the second was child abuse.
Okay. And the third was contempt of court.
Yes.
Okay. Bueno, los antecedentes penales que tiene este acusado es de agresión agravada de un caso anterior, pero los casos fueron tumbados o desestimados. También como caso anterior tiene un cargo anterior por maltrato o abuso de menor y también tiene un caso por desacato con la misma víctima.
All right, your bond on count one is going to be $2,500, the bond on count two, $150.
Las fianzas que se le asignan es como sigue. Para el cargo número 1 la fianza es de $2,500 y para el cargo 2 es de $150.
No contact with the victim.
Prohibido el contacto con la víctima.
Abide by any injunction where you're the listed respondent.
Obedecer cualquier orden de alejamiento que esté en vigor donde usted sea el demandado.
You're not allowed to go to the victim's residence
Le está prohibido ir a la residencia de la víctima.
and not allowed to possess any weapons or firearms.
Le está prohibido poseer armas o armas de fuego.
And then on the on-view violation of probation, the jail will hold you at no bond until your lawyer goes in front of the judge assigned to the case to try to get you a bond.
Y en el caso del que se le acusa de incumplimiento del régimen deportatorio, usted continuará detenido sin fianza hasta que su abogado pueda presentarse delante del juez encargado del caso para tratar de solicitar una fianza.
Do you understand, sir?
¿Entendió?
Sí, correcto.
Yes, correct. Your Honor, by any chance, is there a case number for this case? I know sometimes there isn't. Just check.
Let's see, 2020 CF 3521A.
Thank you.
And then on the BOP, 20 CF 1205. Can you, all right, thank you, sir. And to the interpreter, can you inquire about anyone else speaking Spanish?
Yes, sir. Si hay alguien que necesita un intérprete en español, levante la mano. Levante la mano si necesita un intérprete en español.
Your Honor, we have one more. It's Jose Roman Marrero. He's on the second page.
All right, the interpreter can have that gentleman come on up.
Venga, señor. Venga. Román Marrero.
Sir, can you tell me your name, please?
¿Cómo se llama usted?
José Román Marrero.
José Román Marrero.
Let's see. Your date of birth, September 18th?
¿Su fecha de nacimiento es el 18 de septiembre?
No, enero 20.
No, January 20.
Okay, hold on a moment.
Un momento entonces.
Oh, this one? Okay. You said January 20th, is that correct?
Dijo 20 de enero.
Sí, de 1989.
Yes, 1989.
Thank you, sir. The allegations are that you committed a burglary to an unoccupied vehicle and also grand theft. Can you afford a lawyer? Do you need the services of the public defender?
Bien, las acusaciones en contra suya es de cometer allanamiento con fines delictivos de un vehículo que no tenía pasajeros, desocupado, y también de hurto mayor. ¿Necesita usted que se le nombre un defensor público o puede contratar un abogado?
Un defensor público.
Public defender.
Right, the public defender's office will be appointed to represent you. The bond on count one is $2,500. The bond on count two is $1,000. Do you understand?
Bien, entonces puede nombrarle a los defensores públicos para que lo representen. La fianza en el primer cargo es de $2,500 y la fianza para el segundo cargo es de $1,000. ¿Entiende?
Sí.
Yes.
All right, thank you. Any other
Muy bien,
interpreter
gracias.
cases?
Yes, Your Honor. We have one more. Angel Robles on the first page.
Thank you.
Siéntate, por favor.
Sir, are you Angel Robles?
¿Es usted Ángel Robles?
Sí,
Yes.
Can you afford an attorney or do you need the services of the public defender?
¿Tiene usted dinero para contratar a un abogado particular o necesita un defensor público?
defensor público.
Public defender.
They'll be appointed to represent you. The allegation is that you committed an assault. There's probable cause to believe the offense occurred.
Muy bien, se le nombra un defensor público entonces. La acusación en contra de usted es por amenaza o intimidación y sí existe motivo fundado para creer que usted cometió el delito.
All right, pretrial services, if you could tell us about any prior criminal history, keeping in mind we have the interpreter up to keep up.
Thank you, Judge. Mr. Robles has prior history. His last conviction was 2004.
Los antecedentes penales del señor Robles son que la última condena que él tuvo fue un fallo condenatorio fue en el 2004.
Aggravated battery, trafficking heroin,
Agresión agravada, traficar con heroína,
possession of cocaine, burglary, theft,
posesión de cocaína, allanamiento con fines delictivos, hurto.
Judge, we did actually get to speak with the victim and she wants no contact.
Pues pudimos hablar con la víctima y ella no quiere tener contacto con él.
Your Honor, I do have a probable cause argument. May I be heard?
Yeah, go ahead.
Looking at the affidavit, I don't see any overact which creates some kind of well-founded fear for the alleged victim that the violence was imminent, which is one of the elements needed for assault. I do see that she says that the defendant had means to carry them out, but there wasn't any explanation on how he was going to carry these threats out.
I'll let the interpreter catch up.
Bueno, su señoría, tengo un alegato quiero presentar un alegato en cuanto a motivos fundados, si me lo permite. Sí, adelante. En el affidavit no veo ningún acto donde describa o manifieste que haya un peligro de daño inminente. Sí, es cierto que la víctima expresó temor, pero uno de los elementos para esta acusación, aunque ella dijo que él tenía la manera de llevarlo a cabo, no dio ninguna explicación de en qué manera es que él lo llevaría a cabo, no hubo ninguna explicación de cómo el acusado lo haría.
All right, anything else before I hear from the state?
No, Your Honor. I'd be asking for if probable cause is not met for the defendant to be released ROR.
Lo que pediría es que si se determina entonces que no existe motivo fundado, que se le permita salir bajo palabra al acusado.
Anything from the state?
Your Honor, just
Fiscal.
that the police.
You
Just
can stay
that
seated so you're closer to the microphone if you're more comfortable.
Just that the police report states that the defendant did get in the victim's face and made threats to hurt her. Your Honor, if you don't find probable cause, the state would ask for 24 hours to get a more accurate report from the officer.
Bueno, su señoría, lo que queremos dejar saber es que en el informe de la policía se indica que el acusado pues se le puso cara a cara o enfrente de la cara de la víctima y le hizo amenazas a causarle daño. Entonces, si su señoría determina de que no existe motivo fundado, pediríamos que se nos dé 24 horas para tratar de conseguir un informe más exacto del oficial.
All right, thank you. I find that there is probable cause, notwithstanding the argument. The bond is $1,000 with the following special conditions. You'll be
Muy
up.
bien,
Go ahead.
I'm sorry. Determinó que sí existe motivo fundado, la fianza es de $1,000 y hay condiciones especiales como las voy a describir ahora.
Once you post the bond, you'll be on pretrial release with the following conditions: maintain separate residence, don't possess any weapons or firearms, and have no contact with the victim. And you're not allowed to go back to the victim's residence.
Muy bien, si usted logra salir pagando la fianza, entonces estaría bajo el Departamento de Libertad Provisional con las siguientes condiciones. Tiene que vivir en una residencia aparte o por separado a la víctima. Le estaría prohibido poseer armas o armas de fuego. Le estaría prohibido el contacto con la víctima y le estaría prohibido regresar a la residencia de la víctima.
All right, do you understand?
¿Entendió?
Your Honor, I would also be asking if we can get a one-time assistance with law enforcement so he can pick up his belongings.
Right, you'd be allowed to return one time with law enforcement, but the way that works is you have to contact law enforcement. They'll meet you somewhere other than the property, and they'll accompany you to the property to collect belongings. If you go directly to the property, when the law enforcement gets there, they're just going to arrest you.
Bien, voy a permitirle regresar a la residencia una vez acompañado de las autoridades para recoger algunos artículos personales, pero la manera como eso funciona es que usted tiene que llamar a la policía o las autoridades primero y ellos se van a encontrar con usted en otro lugar que no sea la residencia y luego lo acompañarían a la residencia para que usted recoja esos artículos. Si usted se encuentra con la policía en la residencia, entonces lo que van a hacer es que lo van a arrestar. ¿Entendió?
All right, any other interpreter cases?
Your Honor, I apologize. I didn't hear the bond amount.
1,000 plus pretrial release with those conditions.
Thank you, Judge.
Your Honor, I see no hands.
No hands? All right, thank you. To the interpreter, we'll come back to you in a little bit for the Orange County cases.
Yes, sir. Thank you.
Next case is Rafael Agudelo. The allegations are that you fled and attempting to elude a law enforcement officer with lights and sirens activated and reckless driving. There's probable cause to believe the offense has occurred. Can you afford a lawyer, or do you need the public defender's office?
Public defender, Your Honor.
All right, thank you. Pretrial services, any prior criminal history?
No, Judge. He also meets the criteria for a direct pretrial release, and the court would be able to entertain that.
All right, thank you. The bond's going to be $2,500 on count one and $150 on count two. All right, thank you. Next case is Joseph Barwick. The allegations are you committed a burglary of an unoccupied vehicle and also a petty theft. There's an arrest warrant for that. Can you afford an attorney, or do you need the services of the public defender?
Public defender, Your Honor.
They'll be appointed to represent you. I'm reading the arrest warrant. Give me a moment. All right, yeah, the bond is going to be $3,500 on count one and $500 on count two. Also, no return to the location of the incident. Do you understand?
Yes, sir.
All right, thank
Judge, my apologies, Judge. With Mr. Barwick, we have a case that we had found that the order of exonerating surety bond, I did send it over to the clerk's office. It's unfamiliar, but I believe, if I'm not mistaken, this puts Mr. Barwick back in custody on that case.
Oh, on another case.
Yes, Judge. But I believe this stemmed from September of last year. Mr. Barwick has been transported from Orange, Polk County, and now Osceola for this arrest warrant. And in conducting the history, we did find this case that was open, but I don't see any documentation putting him in custody other than this.
So you want us to do a separate dispo in 2020 CF 646 indicating that Mr. Barwick is in custody on that case. So he's earning credit on that case?
So he would endure some type of credit as the court order was signed September 10th of last year. So I'm unsure. So I'm asking for the court's discretion.
Well, can't you all just have a hearing in front of Judge Wooten to figure out, oh, I'm sorry, it's not going to be Judge Wooten, I think that's Judge Nix, to figure out at what point in time this order...
Because I believe the bond was discharged. We do have him currently in custody on this, so that he can approve some type of CTS. until said motion can be filed.
Yeah, but this, if I remember correctly, I mean, it's been 6 years since I've been in a regular criminal division. What this is the bondsman files a motion to get off the bond because they recognize Mr. Barwick would have been in custody in some other jurisdiction on another case, even before the arrest warrant had been executed on Mr. Barwick in that 2020 CF 646, and then the bondsman agrees to pay for the transportation costs. It doesn't mean that the warrant had been served upon Mr. Barwick. Sometimes what happens, yeah, it just means they get off the hook and don't have to, they're not responsible for making sure that Mr. Barwick gets to the Osceola County Jail. So, I mean, if you want, we can do an order that says that in this 2020 CF 646, that Mr. Barwick is remanded into custody on that case, so it's clear he's earning credit as of today.
And then they can file a motion later.
Yeah, so do you want me to do a dispo, or do you want to take no action on it?
Please the dispo.
Okay, we'll do a dispo on 2020 CF 646.
Thank you, Judge.
Thank you, Your Honor.
I got a blank order there, because I don't have this in blank order.
Yeah, the blank order is fine.
So,
Just say he's remanded in custody on that case number as of today. Can we go to the next one? Okay, Alan, sorry if I mispronounced your first name, last name Cassagnol.
Cassignol, yeah.
All right, you're in custody on an out-of-county warrant from Polk County. My understanding is if you can't afford a lawyer, I can appoint a lawyer to represent you here, and they'll be temporarily appointed until you get to Polk County. Do you want that?
No, I rather one here, sir.
Say that a little bit closer to the microphone.
I'm sorry. I said I rather one here. I rather deal with my case over here.
Yeah, well, I can't let you just transfer the case to Polk County, but what can happen is Polk County is going to be told to come and get you, and they'll get you in the next couple days. Do you want to have a lawyer representing you until then?
Yes, please.
All right, I'll do that. I'll appoint the public defender. Thank you. That's all. Mark Crichton is the next case. Mr. Crichton?
Mark Crichton, Judge?
Mark Crichton.
He's approaching, Your Honor.
All right, thank you. Mr. Crichton, you're in custody on a capias that was issued when you allegedly failed to appear in a criminal traffic case. The bond is $1,000. Do you already have a lawyer representing you, or do you need me to appoint the public defender? Were you able to hear the question, sir?
Your Honor, can you repeat the question? I think he's having a hard time hearing.
All right, Mr. Crichton, you're in custody on a capias that was issued when you failed to appear for court. The bond is $1,000. Do you already have a lawyer representing you? It's for a DUI case.
Do you have a lawyer representing you?
What?
A lawyer.
Lawyer?
Lawyer.
Your Honor, if we could just be provisionally appointed, it seems like he's having a hard time hearing.
All right, I'll appoint the public defender to represent him. They might have already been appointed, but we can't tell. But we'll at least appoint you temporarily now, keeping in mind that if you were permanently appointed before, that still stands.
Okay, thank you, Your Honor.
The next case is Patrick Daniels. The allegations are you possessed with intent to sell cocaine and you possessed drug paraphernalia. Does Mr. Daniels have any priors, pretrial services?
Yes, Judge. He's got possession of cocaine, possession with intent to sell, possession of paraphernalia. He was adjudicated guilty in 2019. He also has possession of cocaine, which he was sentenced to probation on case number 19CF1204. His probation expires in 2022, Judge.
All right, thank you. I'm going to stay the bond at the $7,500 and $500. I know oftentimes the pretrial services or a clerk asks me if I'm going to do anything about the VOP. or on the probation case. I don't do anything on the probation case. I know you all normally let probation office know that there's been a new offense, I'm looking at the clerk, but I'm really talking to pretrial services. I know you all let probation know and they can determine whether they want to file a violation or not.
Yes, Judge.
Thank you. Next case is Anthony Gonzalez.
Your Honor, were we appointed on that case?
The last case? Yes.
Thank you.
Mr. Gonzalez, you have a couple cases here. You have a trespass on school grounds and the resisting without violence. There's probable cause for those offenses. And then you have a separate case where there was a warrant that had been issued for burglary of a structure. Hold on a second. They didn't send that one? Okay. Okay, let me pull it up. All right, hold on one moment. This is one that we didn't get the capias, but I have Smart Bench here, or the equivalent of Benchmark.
I do have a copy if you need one as well.
If I can't pull it up here, I'll borrow your copy.
Yes, John.
Actually, have they assigned that one a case number? The arrest warrant? Right, what's that case number? All right, I see the state filed an information, burglary of an occupied structure, criminal mischief, petty theft, and trespass. So I have to make sure that there's only going to be, what's it? Anthony James Gonzalez. All right, I'm reviewing the affidavit right now. All right, so in the first case, the resisting without violence and the trespass on school grounds, the bond is $500 on each count, plus don't return to the school. And then on the arrest warrant, the bond is $2,500 on count one, and then $100 on each of the remaining 3 counts. I'm gonna leave it at that.
Judge, he meets the criteria for direct pretrial release. Would court be able to entertain that?
Can you say that a little bit louder?
He meets the criteria for direct pretrial release, Judge?
Thank you, but after seeing the affidavit for arrest warrant, reading that and seeing that there's a very similar case that just picked up on that Bill trespass on school grounds, I'm not going to do it, although that doesn't mean your office can't go in front of the judges assigned to the case and see if they'd be willing to do that, but thank you.
Thank you, Judge.
The next case is Cheryl Hayes. Ms. Hayes, you have two different cases. You have a trespass case, there's probable cause, and then a battery. And then there's a probable cause for the battery. I'm about to hear about any prior criminal history for me to set the conditions of release. Up until this point, you've been held at no bond on the battery. Pretrial services?
Judge, Ms. Hayes has got history stemming from 1995, battery, possession of paraphernalia, cannabis, aggravated battery with deadly weapon. That was the most recent in 2018. It was dismissed. It's undetermined. She's got a prior DV charge. The same victim, as to it's unknown. We don't know if it's unknown. Her most current was fraud in Brevard County, which was a withhold. The victim itself is already in custody. He's in this room and he's requesting contact.
Did you say he's in the room and he's requesting contact?
Yes, Judge. He's the victim of Ms. Hayes.
But
They're each other's victims.
oh, right.
We spoke to them separately.
Right. So that's Ms. Hayes, are you asking with regard to the case where you're the listed victim, are you asking for contact too? In reverse?
Yes.
A little bit louder.
Just the situation and
You don't need to go into the facts of the case, although I'm sure the prosecutor would love to hear it. But with regard to whether or not you're concerned that the other gentleman will have violent contact with you, are you concerned about that?
No.
So, both of these people were arrested. Do you have a position on the contact?
No objection if they won't contact you.
That's right.
No, Your Honor, I don't have an objection.
All right, so I'm going to order, okay, so on the trespass, the bond is going to be $500. On the battery, the bond is going to be $500 plus pretrial release. No hostile contact with the victim. Don't possess any weapons or firearms. No hostile contact means no more contact with the victim than the victim allows. You don't have to have any contact with the victim if you don't want to. But if he's okay with you being around him and you're okay with that, then that's perfectly fine, so long as it's non-hostile and we don't want to see either one of you listed as a defendant or victim in any case in the future. You understand?
Yes, sir.
All right.
And just pretrial release on the DV.
Yeah. Bond plus pretrial. All right, thank you. Have a good day.
Your Honor, is the public defender appointed?
Yes, ma'am. Thank you.
Thank you.
Patrick Howell. Mr. Howell, you're in custody on a no bond warrant for your arrest for a violation of probation. Your lawyer would have to go in front of the judge assigned to the case to try to get you a bond. Can you afford a lawyer?
I have one, Your Honor.
A little bit louder. You're so tall, you're so far away from that thing.
I have an attorney.
One more time, a little bit slower though.
I have a private attorney.
You have a private attorney. Very good. Okay. So lots of times private attorneys don't come to court on a VOP since the IA judge doesn't have the ability to change the bond anyway. They just have to go in front of the judge assigned to the case. So they know what they're doing, I'm sure. All right. Thank you.
I already have a bond hearing for Tuesday. Thank you.
All right. Thank you. Jason Kryger, last name Kryiger. When you get to the podium, tell us the correct pronunciation of your name.
Krieger?
Krieger, all right.
Yes, sir.
So there's probable cause for disorderly intoxication, disorderly conduct, although close being in a motel room. But the pretrial services, does he qualify for straight pretrial release?
He does, Judge.
Does, okay. So can you afford a lawyer, or do you need the services of the public defender?
Public defender.
All right, they'll be appointed to represent you, even though you don't have to post money to get out of jail. There's still a pending case, and you're not allowed to return back to that motel. Do you have any stuff there?
I believe I do.
All right, allowed to return allowed to return one time with law enforcement. You'll contact law enforcement that has jurisdiction over the property. They'll tell you how to go back with law enforcement. If you just go directly back to the hotel, they're going to arrest you. You understand?
Understand.
All right, thank you.
So Judge, just for clarification, Mr. Krieger has pretrial release on both counts?
Yes.
Thank you, Judge.
Jarvis McFadden? Mr. McFadden, you're wanted out of Brevard County. The total bond is $50,000. Brevard County will be told to come pick you up. Do you want me to temporarily appoint the Office of the Public Defender to represent you?
Yes, I was told my total bond was $90,000.
A little bit louder. Oh, the clerk just told me my math is wrong. Oh, it's 50,000 plus 25 plus 15, 90,000. And then, so because I was listening to the clerk and I don't want to miss what you said, can you just repeat it?
I was told that my total bond was $90,000.
Yeah, 90,000, right. I don't have the, I'm out of county, I don't have, well, I'll just leave it at the 90,000, okay? So if you can't post it, Brevard County will pick you up. They're supposed to pick you up within 2 business days of being told to come and get you. So you should be there in the next couple of days. If not, you get brought back in front of the judge in Osceola, and they sometimes will let people go. Or they'll hold you again and let Brevard County know. So I don't know what will happen. But usually they're pretty good. We want you out of our jail. We want you over in Brevard County. So we do our best to get them to get you. All right, thank you. Or you can post the bond. The next case is Jose Ramos.
Your Honor, he's in detox.
All right, well. All right, so we'll leave it, we'll roll him over till tomorrow. There is probable cause for the offense, though. Next case is Garrett Rosamond. Can you afford a lawyer? Do you need the services of the public defender?
Public defender, sir.
All right, thank you. There's probable cause of an aggravated assault, a battery, and a criminal mischief. Now I'm about to hear about prior criminal history for me to set conditions of release. Oh, well, this is the co-defendant case. You heard about that, the co-defendant is okay with you having contact with her, and you heard pretrial services tell you that they heard that you were okay with the victim, with the other person having contact with you. Do you agree with all of that?
Yes, sir.
All right. All right, pretrial services, any prior criminal history?
Yes, Judge. Mr. Garrett has history stemming back from 2015. Battery, domestic violence. It's not the same victim. Petty theft, contributing to a delinquency of a minor, burglary unoccupied, possession of legend drug, failed to appear, possession of cannabis in para, which was recent, and they were dropped. His last conviction was in 2017.
Thank you. All right, so your bond on the case will be $1,000 on count 1, $100 on count 2. The next count 3 will be reduced to $100. After you post the bond, you'll be on pretrial release with the condition of no hostile contact with the victim. Do you understand?
Yes, sir.
All right, thank you. Next case is Edward Sanford. Edward Sanford, you're taken in custody on a capias that was issued after you allegedly failed to appear. The bond is $2,000. Do you already have a lawyer representing you?
Yes, sir.
Yes? Okay, thank you.
I have a public defender.
Next case is Richard Santiago. Mr. Santiago, you also, as the co-defendant in your case, had a fleeing and attempting to elude. Any prior criminal history with regard to Mr. Santiago?
Judge, Mr. Santiago only has one prior arrest that was no trunk. It was rolling in 2018. He has no convictions, and he meets the criteria for a direct pretrial release. Would the court be able to entertain it?
All right, and so to set your bond at, I understand you qualify, but based upon the facts, I'm going to set the bond at $2,500. All right, thank you. Next case is David Spear.
Your Honor, does Mr. Santiago did he get appointed to the public defender?
Sir, Mr. Santiago, can you afford to hire your own attorney?
He's asking for a public defender.
All right, appoint the public defender, thank you. Next case is David Spear.
He's approaching, Judge.
All right, thank you. There's probable cause to believe a petty theft occurred. pretrial services. As Mr. Spears coming up, does he qualify? Well, tell me about any prior criminal history.
Judge, Mr. Spear has history stemming back from 1977. His current is 2014 DUI, disorderly conduct, petty theft, grand theft, resisting without, trespassing of a dwelling, trespassing, refusing to leave. He recently went to Michigan in December of last year, got arrested for a traffic offense. We were unable to find the offense and or the disposition was not annotated. So his last conviction was in 2020 for trespass, Judge.
Does he qualify for straight pretrial release?
No, Judge, we're unable to do that traffic offense last month, so
Got it.
we don't know if he's open or on probation.
All right, so your bond's gonna be $250 and no return to the mobile.
Okay.
Thank you. Can you afford a lawyer, or do you need me to appoint the public defender?
I need a public defender.
All right, they'll be appointed to represent you. Next case is Cleother Stoudemire.
Judge, he's detoxing.
All right, there's probable cause to believe the offense occurred. We'll roll it till tomorrow. Dennis Wilson.
He's approaching, Your Honor.
Yes, all right, this case is another one, they don't have the warrant, so let me pull it up. It'll just take a moment. Hopefully the clerk has the case number.
Your Honor, for the warrant?
Yeah, this, do you have the, do you at least have the case number, and I can pull it up that way?
Yes, Judge. Oh, there's no case number assigned on the warrant here.
All right, I'll take, you said you have an extra copy? Maybe I misunderstood. Thank you. What I'll do is the clerk will scan it, and we'll give you your copy back, or do you not need this one? Oh, okay, no, I don't know if you have the affidavit. All right, well, all right, thank you. We'll, on the leave the conditions of release as they are right now, the $5,000 on count one and $1,000 for each of the additional counts, we'll roll it over till tomorrow to see if it needs to be readdressed, either higher or lower, based upon my review of the affidavit plus whatever about hearing about prior criminal history. But I don't have the warrant today, so we'll roll it till tomorrow. If you're still here, you can always post the bond. You understand all of that, sir?
Yeah.
Okay, can you afford a lawyer, or do you need the public defender?
Public defender, please.
All right, I'll appoint the public defender. Matt Rosen. You're in custody on a violation of probation, and bond is no bond. Your lawyer would have to go in front of the judge assigned to the case to try to get you bond. Can you afford a lawyer, or do you need the public defender?
I have a private attorney.
You have a private attorney?
Yes.
Okay, and you probably heard me say to the other individual, usually private attorneys don't show up for court on a VOP because I don't have the ability to change the bond anyway on a VOP. So they probably already know to start going in front of the judge assigned to the case to try to get you a bond hearing. All right, thank you. Next case is Michael Vela.
Your Honor, he refused.
It's an out-of-county warrant. Out of Orange County, he'll be held at no bond. Orange County will be told to come and get him. All right, is there any other case in Osceola we haven't addressed yet?
No, Judge.
I see no hands, Your Honor.
All right, hopefully the video will be working tomorrow. All right, I'm going to hang up here.
Thank you, Your Honor.
Yeah. No. We didn't appoint the PD. We just rolled it to tomorrow to see if he comes. Yeah, so we have to still give him one more chance to show up. But, yeah. Well, put it for Monday. Yeah, no point in having him for tomorrow, because maybe Monday Orange County will have already gotten him. So Mr. Vela, we're going to put for Monday. All right, Andrew. All right, how do I switch this over to? Are you looking for me? Hey, how's it going? Yeah, it's been for a long time. Oh no, what's this? Oh, okay. But he's already out of the jail?
He's here.
Oh, okay. Can we serve it on him?
We can't serve it until it gets to the warranty and they verify it.
Oh, okay.
No, I got it. Because she's able to stay in present court.
Are we gonna see him for something else?
He was bonded out, so he closed out his charges.
Oh, okay. So they won't release him with this in the system, right? You all won't release him, right?
I had her make one.
Oh, you see, okay.
She did it for me.
Right now, I'm holding him on the local warrant.
Just make it the last man.
It's loose, but I'm holding.
Oh,
him
you
on
just
that.
need me to sign an order that says hold him on the wall?
Correct.
Yeah, that's fine. I mean, it looks valid to me. And they just issued it yesterday.
I can't do nothing. I cannot do nothing.
He's in Spanish interpreter, so Captain Gonzalez.
Oh, perfect, thank you.
Hey, how are you doing? Every time I think of the word we, I think of you, remember in court talking about the royal we. So I think about you often that way, even though I haven't seen you in 6 years.
It's good to see you. It's so good to see you. How's juvenile?
Well, the week has been great. I got one of the prosecutors right there.
Okay.
Yeah. So it's been enjoyable. But I heard you say the other day that you were new to the division. Were you in the other division or?
Me? No, I was in county court. I just got moved up.
County court. All right.
I only started at the office about a year and a half ago, so
All right. Time flies.
fairly new.
Why is it so? Is there a fan of it? It's so loud in here. What's that? It's that.
Vent thing.
Yeah.
I know you can't hear anything. I'm saying it.
So we have to do the interpreter cases first. But what's your client's name?
Your Honor, I actually have 2 clients on the docket.
2 people. All right. Who are the 2 people?
The first one is O'Shea Stuckey.
And what's the other one?
Jamel Rowe, R-O-W-E.
R-O-W-E. Yeah, Rose a felony. Yeah, I remember that. Because I'm mentioned in the police report. I don't know if you had a chance to read it.
You are in the...
Yeah. I wanted to explain to him what no contact means. The client of yours.
Your Honor, I'm sure that my client would not mind my explanation to him that...
I don't even know if we're being recorded yet, just so you know.
But if we're off the right, I mean, I can't say what my confidence, but typically I would say, among other warnings, you know, there are 3 billion plus women in the world, but one of them has the ability to put you in custody with no bond. Why in the world, out of the billions, would you contact that person? Why? Makes no sense. Mathematically, not in any other way. Please don't.
So, yeah, I mean, because when you read it, it says, and it says I rejected the warrant. So just so you know what happened is, he sent a warrant in. And then he told me, hey, we arrested him. What are we supposed to do with the warrant? I go, well, I'm going to just hit reject on our computer screen. Before I even had a chance to read it. It wasn't like I rejected the warrant and they arrested him.
No, I did see that.
Yeah, so, so what happens is they have the ability to send those electronic warrants to us. And sitting right here, I have 8 of them to review at some point. And so I hadn't touched it yet. So I got a call from communications, and they record these calls, I believe. And he goes, what am I supposed to do about the warrant? I go, I'm just going to hit reject about it. And I'm pretty confident that I hadn't reviewed it yet. Otherwise, I would have taken action. So that wasn't like I rejected a warrant based upon. But I just wanted you to know since it said it.
No, it was pretty clear what had happened in the arrest affidavit, saying that he'd previously been arrested by the time you were.
Got it. Okay.
The warrant was to you. So thank you.
Yeah, no problem. So I'll do the interpreter cases, and then we'll do your 2 people. I don't even know what button to push at this point. The DRC.
Yeah, thank you.
I'm just glad that I got a face mask covering my facial expression.
Good morning, Your Honor. Carlos Morales, State Certified Spanish Interpreter, previously sworn.
Thank you. And you were previously sworn by us this morning in Osceola. All right, so we'll bring the first interpreter case.
Your Honor, and just a heads up for the court, for some reason I'm having some technical issues. Doesn't seem like I can connect to the headsets, so I think we'll have to cover it over the PA. I apologize, I'm not sure what's going on.
Not a problem. And this, I should have told you this for Osceola. As soon as we reach the point where you're getting concerned that we're speaking too much, just start interpreting and we'll know to be quiet.
Okay, thank you.
So that monitor stays just like that the whole time.
Yeah, well, I saw they're supposed to open, you know, for us to see them.
Right, but once we're done with Osceola, they just leave the monitor right there? Oh. Okay.
You want us to move this?
No, it's all right. I'm tall enough to see. Sir, are you Anthony Gonzalez Barrios?
¿Es usted Anthony González Berrios?
Baires.
Baires
González.
González.
And your date of birth is October 25th, 1997?
¿Y su fecha de nacimiento es el 25 de octubre del 97?
Sí.
Yes.
All right, you're here today based upon a battery on a family or household members that phrase is defined by law. There's probable cause to believe the offense occurred.
La acusación en contra de ustedes por agresión a un miembro de la familia o del hogar, según lo define la ley, y sí existe motivo fundado para creer que usted cometió el delito.
Now, I'm going to make this announcement to the people in the audience here. If you are here on a case that I call, come on up to that door and the corrections officer will let you into that room. So if you're here on Anthony Gonzalez Barrios, come on up. And the interpreter, you might need to interpret that.
Bien, este mensaje va para las personas que están en el auditorio. Si usted está aquí presente porque va a testificar en un caso, acérquese a la puerta y entonces uno de los oficiales le va a permitir entrar. Estamos tratando el caso del señor González Barrios, entonces si usted tiene que decir algo en ese caso, acérquese a la puerta, por favor.
I see no one moving towards the door. All right, so in this case here, as I said, there's probable cause, so there are some conditions that I'm required to order, such as that you have no contact with the victim, that you maintain a separate residence from the victim, that you don't possess any weapons or firearms, and you don't go back to the victim's residence.
Hay ciertas condiciones que debo imponerle, ya que se determinó que existe motivo fundado. Le está prohibido el contacto con la víctima. Tiene que vivir en una residencia aparte o diferente a la víctima. Le está prohibido poseer armas de fuego o armas. Y le está prohibido regresar a la residencia de la víctima.
Except that you're allowed to return one time with law enforcement to collect your belongings.
Con la excepción de que le es permitido regresar una vez a esa residencia acompañado de las autoridades para recoger artículos personales.
And the way that works is you'd contact the sheriff's office, tell them you're allowed to return one time, and they'll meet you away from the property and they'll accompany you to the property. Don't just go directly to the property without law enforcement.
Y la manera como eso funciona es que usted tiene que llamar a la policía o a las autoridades, les deja saber de que usted le ha sido permitido regresar una vez acompañado a las autoridades. Ellos se van a encontrar con usted en otro lugar que no sea la residencia y entonces lo acompañarían a la residencia para luego entonces usted recoger sus artículos personales. No vaya usted directamente a la residencia sin ellos.
It looks like from the criminal history, and I take it the state and PD get a copy of the first appearance information sheets?
Yes, Judge.
Okay.
And just for the record, Brenda Chikansky on behalf of the Public Defender's Office.
All right, thank you. And it looks like, if I'm reading this correctly, there's minimal history, and he qualifies for a pretrial release after a bond is posted, right?
He qualifies for a direct PTR, if you wanted to give it, Your Honor.
Oh, yes, I'll do that.
So, just straight PTR?
Straight PTR. The rules in Osceola apparently are different than here, so no problem. So you don't have to post any money to get out of jail, but if you violate any of these conditions of release, you're going to be right back in the jail.
Bien, a usted se le va a permitir salir directamente bajo la supervisión del Departamento de Libertad Provisional, así que no tiene que pagar fianza o dinero para poder salir, pero si usted quebranta o viola alguna de estas condiciones sobre su libertad, va a terminar de vuelta en la cárcel. ¿Entiende?
Sí, entiendo.
Right.
Yes, I understand.
Thank you.
And he does just have to be informed, Your Honor, he does have an immigration hold.
Okay, so apparently the jail might not let you out right away until this immigration hold is cleared up. I have no control over that at this point in time.
Se le tiene que informar además que hay una retención inmigratoria o detención inmigratoria sobre usted, así que es posible que la cárcel no le permita a usted permita salir pronto, hasta que eso se resuelva primero, y yo no tengo ningún control sobre eso.
All right, thank you.
Thank you, Judge.
Your Honor, also, if there are any case numbers for the cases, if the interpreter may please have those case numbers.
21 MM 199 AO.
Thank you.
All right, next gentleman, step up to the podium and tell us your name, please.
Acérquese al atril. ¿Cómo se llama usted, señor? ¿Cómo se llama usted? ¿Cómo se llama usted?
Jesús Casilla.
Jesús Casilla.
Since there's very few people in the courtroom, I don't know if you're still going to waive the reading of the charges.
I'm sorry, Judge?
So, I've seen many times when people have these kind of cases that the public defender says we waive reading of the charges, but then again, there's very few people in the courtroom, so I don't know if that's what you're trying to do. I'm just,
We can waive formal reading, Judge.
fair enough, all right.
Thank you.
Thank you. Sir, you're in custody on 3 charges.
Señor, usted está detenido por 3 acusaciones en su contra.
There's probable cause that the offenses occurred.
Sí existe motivo fundado para creer que se cometieron estos delitos.
You're entitled to bonds on counts 2 and 3.
Usted tiene derecho a recibir o que se le asigne una fianza en los cargos 2 y 3.
The bonds on count 2 will be $10,000. The bond on count 3, $5,000.
La fianza para el cargo 2 será de $10,000 y la fianza para el cargo 3 será de $5,000.
I do see that you have no prior criminal history, but your bond on count 1 is going to remain at no bond until you, for the state to have an Arthur hearing within a reasonable time to see if the state can hold you at no bond.
Y veo que aunque usted no tiene antecedentes, para el cargo número 1 no se le está asignando fianza. Eso hasta que la fiscalía pueda comparecer delante del juez y se pueda celebrar una audiencia que se llama tipo Arthur para ver si la fiscalía puede demostrar que se le puede detener sin fianza.
Now, the way I heard that this works, and I just want to make sure, is that the state attorney emails the state attorneys in that division to have the hearing held. That's how, at least it's in Osceola. I don't know how it's possibly done
I
here.
believe so, Your Honor. I mean, I would also, if you can give me a moment, I can get you a better,
I mean,
clear answer.
They can't hold them indefinitely at no bond. There has to be the hearing within a reasonable time. All right, but that's internal workings from your office.
Yes, Your Honor.
Okay, thank you. All right, so keep in contact with your lawyer.
Manténgase en comunicación con su abogado.
All right, any other interpreter cases?
Case number, please, sir.
Oh, the clerk will read out the last case number. The one we just did? Oh, this one right here, 2021 CF 329AO.
Okay. And may the interpreter be excused?
Yes,
then,
sir, thank you.
Thank you. Have a good
No special condition or nothing?
No, right, because he's being held no bond.
He said no condition.
Is this your client? On that last one, he's held it. No, he's held at no bond, so. All right, so, Mr. LaFay, which of your 2 clients are we addressing first?
Your Honor, I have O'Shea Stuckey.
Okay, give us just a moment to pull that case out. And the clerk's asking me a question about my last case.
No, I was, he said no contact, so you can't.
Did I say that?
No, you didn't say
I didn't say.
Oh, okay.
But he's held no bond, it's not anything. Okay, got it here. So O'Shea Stuckey, I see that there's 3 cases. Two of them are on view, and then violations of probation, and the other case is a possession of drug paraphernalia and a possession of less than 20 grams of cannabis. And there's probable cause to believe the paraphernalia and cannabis occurred. So, Mr. LaFay, you wish to be heard?
I do, Your Honor. I've reached an agreement with the State Attorney's Office that with regard to the new charges, that Mr. Stuckey would be released on a $2,000 bond.
So 1,000 per count?
Yes, Your Honor.
Okay, fair enough.
And
Keep
then the VOP holds would be vacated, so he is eligible to be bonded today.
Okay. So so he, I just want to make sure we have the words correct. So it's just going to be, it's,
So on the OND, you taking no action on the OND, or are we just gonna release an ROR?
he's just, so it's, I mean, what happens is, my understanding of the law is, no matter what I did on the on-view VOPs, if I give him a bond or release him ROR, it doesn't stop the probation office from still violating him. So he's just going to be released on those two cases without prejudice to the state for the state to file an affidavit of violation of probation.
Correct, Your Honor.
Okay, fair enough. So that's the agreement state, right?
Yes, Your Honor.
All right, thank you. Not that I doubted it, but I wanted to make sure I heard it correctly. All right.
I'll call your family. Get out of here. Get out of here.
Right.
And then the VOP, you releasing him.
Yeah, release it and say without prejudice for the state to file an affidavit of violation. All right, your name, sir?
Jamel Rowe.
All right, thank you. All right, so allegations are you committed aggravated stalking with a credible threat and carrying a concealed weapon. So there's probable cause to believe the offense has occurred, and now I'm just going to take a moment to explain what no contact means, because it's a condition that I'm going to order in the case. And sometimes it's easy for me to take a couple minutes with someone to explain what no contact means so that there's no confusion. The only exception to the no contact is your lawyer. Like if Mr. LaFay is your lawyer. So he, on your behalf to defend you, is allowed to contact the victim. So like maybe he's going to try to schedule a deposition, or maybe he's going to be at the deposition. Obviously, he's going to have interaction with her. That's the only possible exception. Let's
Understood.
not talk about Mr. LaFay for a moment, but let's say we had, other than Mr. LaFay, the best possible legal mind that exists in the entire world. Maybe it's Mr. LaFay. But I'm saying is that person can't come up with any loophole to this no contact.
All right.
The only person is your lawyer can defend you, and if the defending you is your lawyer, member of the Florida Bar, not someone with the power of attorney. Mr. LaFay is the only person on your behalf that can contact the victim. You can't ask someone to relay a message. If you get out of jail today and you post and you win the $500 million Powerball lottery today and you gave it all to her, the listed victim, she could keep the money and you violated the no contact order. It doesn't matter whether it's good contact in your mind or not. No contact just means no contact. Nothing. Let's pretend for a moment that you saw an invitation or a request from the victim to have contact with you. Let's say for some reason you thought that she left you a message that says, I forgive you, I love you, come to me. Unless someone has changed this court order, if you were to go to the victim's place with her permission, you're violating the no contact order. So anything you see that you think might be the victim trying to get you to come over, don't fall for it. Because no contact means no contact. And that remains in place until the case is over or until a judge signs an order that modifies it. So unless Mr. LaFay tells you that you're allowed to have contact, no contact, nothing. There's a lot of people who are in jail at no bond because they don't understand what no contact means. But I've never had anyone that I've said that have taken a couple minutes to explain what no contact means. I've never had any of them show back up. And this no contact thing is so broad, there is a case, and cases are like appellate court cases, they're binding upon all of us, where some guy posted on his Facebook some message. But he knew that the girl that he knew and him, the defendant, had mutual friends. And the court said, well, he should have known that those friends would have relayed a message that he posted on Facebook. So even that got that guy back in jail. So don't do anything that might cause some message to be relayed to the victim. Otherwise, you're going to be right back here again. So I wanted to make sure you understood what no contact means. I'm not asking you to comment about the facts of the case. I'm just saying, do you at least understand what no contact means? It's just a yes or no.
Yes.
Okay. So you're entitled to bond. This is not a case where I can hold you at no bond. And so now we're going to talk about any prior criminal history that you may or may not have. So just give me a moment. So Mr. Lefebvre, I don't know if you saw, and I haven't pulled it up yet. Would they give us these sheets that said what people's prior criminal history is?
Your Honor, if I could, my information is that Mr. Rowe has no prior criminal history whatsoever, and I understand that the court found probable cause, and I'm not here to quarrel with the court's finding, but I would like to put on the record I had two arguments with regard to probable cause as to aggravated stalking, if I could make them.
Yeah, go right ahead.
The first is that, you know, when I read the arrest affidavit, it says that here is the threat that is laid at Mr. Rowe's doorstep. If you date my best friend, I will kill him. That is a conditional threat, number one. A conditional threat is a non-threat. A conditional threat is legally not a threat, and it definitely cannot qualify as a credible threat. Second, under 748.048, which is the aggravated stalking statute, if we look at paren C, it says the threat must be made to someone who is closely related to the victim. The only thing in this affidavit is that the person who the threat is directed against, the person that the victim wants to date, is the best friend and closely related, we would presume, to Mr. Rowe. But that is not what the statute says. It says that the person has to be closely associated, I beg your pardon, quote unquote, in paren C, to the victim. And there's just no evidence of any close association between this threatened person and the victim. Thank you. Those are my arguments.
Thank you.
So I would say, and I beg your pardon, sorry to give a string argument, I'd say clearly there's probable cause for stalking, but not aggravated stalking. Thank you.
You're welcome. I read the rules to say that when I review these police reports, and if a person is charged with two separate counts, my question is there probable cause to believe that two separate accounts occurred, two separate offenses, and clearly two separate offenses occurred, even if it's a lesser included offense of what's set forth on the report. And I do see here that on Mr. Rowe, that your information about no priors is consistent with what the jail has provided the state and the court and presumably the public defender's office. But I understand those forms don't leave the courtroom. But anyway, so state, anything you want me to consider other than the police report before I set the conditions of release?
No, Your Honor.
Your Honor, I've spoken to the family. Mr. Rowe's mother is actually in the gallery, and they've said that they have the finances. The finances are a little bit tight right now, but they have the finances for a $2,000 bond if they went through a bondsman. And of course, no objection. I mean, it's standard for the no contact. Thank you.
Right. So, and he qualifies for pretrial release after the bond is posted, right?
Or direct, Your Honor, it's up to you.
Well, I get that, but I'm going to set the bond at $1,000 on count one, $150 on count two, plus pretrial release with the condition of the no contact. But the fastest way to get back here in jail is to violate the no contact order. So don't do that. Hopefully you're...
Your Honor, this case also involves carrying a concealed weapon. If we could have a no weapons order as well, Your Honor.
Yeah, fair enough. Don't possess any weapons or firearms.
Thank you, Judge.
Right,
Thank you, Your Honor. If I could be excused, Your Honor, good to see you.
It's good to be back.
So.
Yeah, have a good day.
You too. Stay safe.
Have a good weekend, Mr. Lefebvre.
Thank you.
It was nice meeting you.
You as well.
Good to see you. Sure, I'll see you in front of the... I'm sorry?
Am I supposed to do something special with these? Do you take these back? Oh, you give them to the clerk?
Yeah.
Oh, okay, I'll just stick there. All right. So now we're in the move-ups? Oh, in that one? All right. Right, yeah. No, I only have to stop for emergencies. Your name, please?
Older Omar.
Omar Quinones?
Older Omar.
All right. The allegations that you committed a burglary of a conveyance and petty theft. The public defenders want to be representing you in this case. And let's see.
Yeah, pardon me. I mean, today technology, they can find retina.
Does he qualify for mental health pretrial release?
It records everything. The
He
photo
could be,
sensor, so. Today
we
technology.
could try, it's up to
Carl
mental
Zeiss
health.
technology.
They're the ones that
Okay.
do the evaluation for it.
Okay, so what I'm going to do in your case is your conditions of release are going to be mental health pretrial release, but in the event that you don't qualify for mental health pretrial release, they'll release you on straight pretrial release, but that's only if mental health determines.
Well, he doesn't, we didn't interview him, Your Honor, so
Oh,
I
you
don't know if he
haven't.
would even qualify for straight PTR with us.
Okay.
Usually we just ask the bond to be set in case they don't qualify for mental health PTR, then at least they can still bond out.
All right, so your bond on count one is going to be $1,000, the bond on count two, $250, if you don't qualify for the mental health pretrial release.
Thank you, Your Honor.
Next case is last name Johnson. Hi, your name, please?
Johnson.
All right. You're in custody because you allegedly failed to appear for court. They set the bond on the capias at straight pretrial release as an add-on charge is something that you're already here on. So. Apparently you're in jail on some other charge other than this one, and so they realized that there's this outstanding capias for your arrest, so they just brought you here to tell you that you're being served that capias. The conditions of release on that case are just straight pretrial release. You won't have to post a bond to get out of jail on this case. You might have another case, but this one, you don't have to post any bond.
So I mean, regular release, straight release.
Well, it's a complicated answer because sometimes people have multiple cases. You apparently are one of them. This case here, the one where you allegedly failed to appear for court on a disorderly conduct and resisting without violence, on that case, you don't have to post any money to get out of jail. If you have another case that has a bond, then you have to post that bond.
I only got one case.
All right. So the
I've been here
jail
a
may or
whole-
may not agree.
Here's two other cases, John.
I've been here a month already.
What's that? Are you holding him on another
He
case?
has two other cases.
Oh, the clerk
34
thinks you have
days.
two other cases. I'm sorry, the jail thinks you have two other.
I mean,
But you have the
34
public
days.
defender representing you on the cases, right?
Yes, Judge.
All right, so they'll be able to defend you. All right, but in this case, no, you're released without having to post a bond.
Thank
Are
you,
there any
Judge.
conditions with the PTR, Your Honor?
No, they just said straight PTR,
Thank you.
but I appreciate the question.
On that case, about the bond, that we did the order, she said, the original went back on, he was back in jail on that case for the bondsman. And his original
Stone?
bond was $1,500.
Are we not doing Ramos?
I have no bond.
He was on the. Oh, okay.
Yeah,
What
but
did
they
they say
can
about
readdress
Ramos?
it.
Yes.
They can't call it over.
Hi, are you Tiffany Stone?
Yes, sir.
All right. Are you able to hear me all right over there? I mean, sometimes when I hear people talk to me, the volume's not that good. So can you hear me all right over there?
We can, Judge.
I can hear you, yes,
All
sir.
right. The allegation is that you trespass after warning at Party Liquor, so you're not allowed to return back to Party Liquor. And now we're about to see whether or not, let me see about any prior criminal history. Does she qualify for pretrial release?
She does not, Your Honor.
All right. So the bond is $250 is what I'll do, even though it says $5. So I don't know if this is one of these that the state makes a plea offer or not.
Your Honor, I only make them on the misdemeanor pleable category, so there's no offer at this time.
This is a trespass on property after warning. I don't know if that's a misdemeanor pleable to y'all.
I have it.
Oh, it might have, Your Honor, it might have come out of the pile. I forgot we're in the move-ups.
Yeah, take your time.
One moment, Judge. Oh, yes, Your Honor, my apologies. State's offer in this case would just be a credit time served offer with no return to the scene, Your Honor.
I don't know if you
Is
had-
that with a withhold of
With an-
adjudication?
with
or
an adjudication of guilt.
An adjudication of guilt, okay. May I have just 1 second,
Yeah,
Judge?
go ahead.
Judge, my client has chosen to accept the state's offer. I did go through the preliminary issues when pleading out, but I don't know if Your Honor needs to do a separate colloquy.
Do you have the plea form there or no?
We do,
But she hasn't read it.
not yet.
All right.
I
So-
can go over it quickly with her.
If I'm looking at the arrest report, well, not arrest report, criminal history. You've had a couple felonies and a couple misdemeanors before, if this is true. So if you've ever pled to a charge, you probably have been advised of your rights, correct?
I understand.
What's that?
Yes, sir.
Okay, so I'm gonna go over them, but if I go too quick, just let me know to make sure that, we want to make sure you understand what's happening here. If you enter a plea of guilty or no contest, it means you give up the rights of, the right to have a trial, to make the state prove the allegations against you, the right for you to testify or remain silent. You give up the right for your lawyer to challenge and cross-examine the witnesses and evidence against you. You give up the right to subpoena witnesses to testify on your behalf. Does that sound like everything you've heard before in the prior cases?
Right. It sounds like everything I heard before, and every time I really don't like the way it sounds. I wish we could reword it, but yes, I understand.
Well, I mean, if you think about it,
But I accept the
Every
time
tri-
served offer. Is
Got
that
it.
that's the right understanding?
right? Because if you basically are skipping the trial and going right to sentencing. And so
Right.
anything you've ever seen regarding the trial, you give up those rights. And it's just, we just want to make
Understand.
sure people know that. We don't want you to leave here and be like, what? When's my trial?
No, I understand.
So if you enter a plea of guilty or no contest, you'd be adjudicated guilty. You were arrested yesterday, so we sentenced you to 2 days, so you'll be released today.
Sure.
There's mandatory costs, and what do they usually do? Just give them time?
Court costs, cost of prosecution, Your Honor.
And apparently we give you a year to pay it.
Understand.
All right, so do you know that a plea of guilty means to admit it, go ahead and sentence you? No contest means you don't admit it, but you don't deny it, and whether you plead guilty or no contest, the sentence is the same. Did you know that?
I understand.
And not guilty means you deny the allegation. So
Right.
to this charge of trespass on property after warning, the second-degree misdemeanor, do you plead guilty, not guilty, or no contest?
No contest.
Are you in the no contest plea because you believe that's the best way to resolve the case for you?
Yes, sir.
All right, I find that you knowingly, freely, and voluntarily have entered your plea with an understanding of the nature of the allegations and consequences of the plea, and there are sufficient facts to support the acceptance of the plea, and I'll give you the sentence that I told you you'd receive.
Understand.
Do you have any questions for me?
No, sir.
All right, you have 30 days to appeal the judgment and sentence of the court. If you do so, you must do so in writing to the clerk of the court. If you can't afford an attorney, one would be appointed to represent you, okay? All right, good luck.
Understand.
You'll
Yes,
be
sir.
released today.
Thank you, Judge.
You need me to sign this?
No.
Ashley Vernon?
Yes, sir.
All right, step on up. All right, so the allegation is that you committed a possession of drug paraphernalia. Now, originally there was a bond of $500, but the jail wouldn't let you post the bond because
I'm
you're...
out on bond.
What's that?
Because I'm out on bond.
Right.
You're not revoking it, are you?
Well, every case is different, so I always think about whether it's appropriate or not. But in your case here, after consideration of about prior criminal history and so forth, I'm going to not revoke the bond, but I'm going to make the bond higher on your new case, where the bond is $2,500, and there is probable cause, and the public defender's office will represent you.
Okay, 1 second.
So-
I'd rather you ask me the question.
Can't I?
Oh, is this, no, it is, okay.
All right, so I'm not revoking the bond, but you have a higher bond than you probably thought you were going to get. So sometimes that's what judges do, and then other times judges revoke the bond. But you have the public, if you can't afford to post the bond after trying, your lawyer can go in front of the judge assigned to the case to try to get you a lower bond. Does that make sense?
Judge, this is on the misdemeanor pleable list, so I'm not sure if the state was willing to make her an offer.
Oh, we'll find out.
It is a misdemeanor paraphernalia charge.
Your Honor, the state's offer would be a credit time served offer, adjudication of guilt. Court cost of prosecution, Your Honor.
What is the cost of prosecution? Oh, just the
I think
150
it's
or 100?
$100 for a felony, $50.
I was confusing myself with cost of investigation, so I got it. All right. Now, just make sure you know that this doesn't mean that the state can't still go to the judge assigned to their prostitution case and try to get that judge to revoke the bond. This
I
is
know.
just, it just means you'll be released today on this
Yeah, I'm
case
just
here.
gonna talk to my bondsman right when I leave here.
Thank you very much, Judge.
Some people don't know this, but unless the law has changed, people who really do have a third-time prostitution, I think there's if people want to do diversion, I think there's a condition on the statutes that allow for that. Just something to look into.
Yes.
Absolutely, Judge. She does want to accept the credit time served offer on the new offense.
All right. So, did you hear about the rights that I went over with the last person?
Yes, sir, I did. I was listening.
So you understand you give up the right to a trial, the lawyer representing you at trial, to
Yes, sir.
cross-examine witnesses as evidence against you, to subpoena witnesses and so forth. You understand all that?
Yes, sir.
All right, do you understand the difference between guilty, not guilty, and no contest?
Yes, sir.
To the allegations that yesterday that you possessed drug paraphernalia, the first-degree misdemeanor, punishable by up to a year in jail and a $1,000 fine. You plead guilty, not guilty, or no contest.
No contents.
Are you entering the no contest plea because you believe that's the best way to resolve the case for you?
Yes, sir.
I'll accept your plea. I'll find that you knowingly, freely, and voluntarily have entered your plea with an understanding of the nature of the allegations and consequences of the plea. There's a factual basis to accept the plea, adjudicate you guilty, sentence you to 2 days in jail with credit for 2 days' time served. Those mandatory costs will give you 1 year to pay. Any
Yes, sir.
questions?
So with my other bond not being revoked, I can still go home today, right?
That the jail will not hold you on this case, right?
Okay, thank
Anything
you.
else? Well, last thing, you have 30 days to appeal the judgment sentence of the court. If you do so, you do so in writing to the clerk of the court. If you can't afford an attorney, one will be appointed to represent you.
Yes, sir. Thank you.
Thank you. All right, and to the people in the audience, when you hear a case that you might be connected to, come on up to the window or the door there. Joseph Dorville. Is that you, sir? Are you Joseph Dorville?
Yes, sir.
All right, based upon the affidavit of indigency, you qualify for the public defender. They'll be appointed to represent you. There's probable cause to believe that you committed a battery by strangulation and also domestic violence battery. I mean, it's really the same incident. So now about the set conditions of release, you've been held no bond up until now, and now we're setting conditions. So I have to order that you have no contact with the victim. No contact means none at all. Your lawyer can defend you, lawyer, member of the Florida Bar, they can defend you, but there are no other exceptions to the no contact order. There's no good or bad, no direct or indirect. You send her $1 million, that's a violation of the no contact order. It doesn't matter if she keeps the money. You understand? For the record, you're shaking your head yes. So no contact with the victim. You have to maintain a separate residence from the victim. Not allowed to possess any weapons or firearms, and not allowed to return except for one time with law enforcement to collect some belongings. The way that works is you'll contact law enforcement. Looks like OPD is that law enforcement. They would accompany you to that location where this offense, to the location where this offense occurred. If you have any stuff there, if you all have a different residence, then you'd have to contact. If you live somewhere else other, like for example, well, actually, do you even have any belongings where the victim lives?
I left my car there.
What's that?
My car.
That's your car. All right. Well, so unless the victim doesn't live in your car, so you still be allowed to get the car. But I'm talking about where she lives. Do you have any belongings where she lives?
Close.
What's that?
He has clothes there, Judge.
I'm sorry, I didn't hear that.
He has clothes.
Okay, yeah, allowed to return one time with law enforcement. Contact law enforcement who has jurisdiction over the property. They'll tell you the procedure. And then it looks like, according to this, no prior criminal history.
And he does qualify for a direct PTR, Your Honor.
All right, you won't have to post any money to get out of jail, but the case is still pending, and if you violate any of those conditions that I mentioned, it'll cause you to be right back in jail. Do you understand, sir? All right. Straight PTR, yeah. I mean, I see speakers above me, I just can't hear anything out of it.
All right.
Hi, are you Leslie Erickson? All right, the Public Defender's Office will be appointed to represent you based upon your affidavit of indigency. There's probable cause to believe that you committed battery on a family or household members of phrases defined by law. The victim's not here, so I have to order that you have no contact with the victim, that you maintain a separate residence from the victim, that you don't possess any weapons or firearms, and that you don't return to the victim's residence except for one time with law enforcement to collect any belongings you might have. It looks like minimal criminal history. Does she qualify for a pretrial release?
She does, Your Honor, yes.
All right, so you won't have to post any money to get out of jail, but if you violate any of these conditions that I mentioned, it'll cause you to be right back in jail. Do you understand?
Yes, Your Honor.
And no contact means no contact. There's just no way around it. No good or bad, no direct or indirect. If you violate the no contact, it'll cause you to be right back in jail. Let's just test your understanding. Victim calls you on the phone, says, I love you, I miss you, I want you to back. Can you say anything back?
No.
That's right, because it would be a violation of the no contact order. All right, thank you.
Thank you.
Thank you, Judge.
Next case is last name Gaskin.
Good morning.
Good morning. And so the allegations is that you committed the offense of stalking. There's probable cause to believe the offense occurred, and the Public Defender's Office will be appointed to represent you in this case. I don't see the victim present, so I have to order at the minimum that you have no contact with the victim, that you maintain a separate residence from the victim, that you don't possess any weapons or firearms, and you're not allowed to return to where the victim resides except for one time with law enforcement if you have any belongings there. You'd contact law enforcement, tell them you're allowed to return one time, and they'll tell you the process. Don't just go to the victim's residence. And you're not allowed to possess or consume any alcohol. All right, and now look at prior criminal history. Let me see.
You don't have the list? I think it's in the list. His first name is L-E-C-H-A. L-E-C-H.
State, what is this? They're showing that she's out on bond on a case. Do you know what the status of that case is?
If you give me one moment, I can get that for you, Your Honor.
It looks like it's 2020 CF 2413.
Your Honor, that case is scheduled for PTC in March 9th. It appears that the last...
And did you all file it as the petty theft with two priors?
Yes, Your Honor, it's a petty theft with two priors and an obtaining merchandise money with false receipt, one F3 and one misdemeanor first degree. And it appears the last hearing was November 23rd, which was canceled because of the coronavirus restrictions on trials, Your Honor.
All right, so your bond on the new case is going to be $1,500 plus pretrial release with the conditions that I mentioned. However, even if you post the bond, they're not going to let you out of jail because that outstanding case that you had that was just discussed, your lawyer's going to have to go back in front of Judge in Division Number 19 to try to readdress your conditions of release in that case. You're entitled to conditions of release, but you have to go back in front of that judge to try to get the conditions of release readdressed based upon the new case.
Could you explain to me? I don't understand now. I'm really lost.
I'm going to do my best here. You have a new case,
Yes, sir.
and you have a bond on the new case. You're with me so far, though, right?
Okay, I got a bond on this one.
Yeah, exactly. Right.
Okay.
So you had, when you walked into court this morning, there was already an open case that you had in Division Number 19 that's scheduled for a pretrial conference in March. It's an open case in which you posted a bond to get out of jail.
It's like over a year ago.
Yeah. And so, but the law says that if there's probable cause to believe a crime occurred while the person is out on bond, the court can revoke the conditions of release. And then what happens is you go back in front of the judge in Division Number 19, and they tweak the conditions of release in that case because those conditions presumably didn't work. So that judge can't hold you at no bond unless no reasonable conditions of release exist. So you're entitled to. So that's where we are. So you have a lawyer representing you in the case today, and you have a lawyer representing you in the other case. And if it's like the public defender's office, like I remember, they probably have 4 attorneys in front of that judge Monday through Friday in division number 19. So they know how to go back in front of the judge to try to get you a bond. So that's, I want to make sure, you might not be happy, believe me.
I don't.
People,
I'm sorry, Judge, just for the record, would the court consider raising the bond amount on the case that she's out on monetary release?
so what I'm going to do is very rude because I got to answer this call, which looks like it's an emergency issue. Hold on, for the on-call. So we'll come right back.
Absolutely, Judge.
Emergency duty phone.
So here's the thing.
Yes. Okay, hold on while you're on the phone here, because I'm hitting refresh to see if it pops up on the screen. Oh, maybe you have to sign out back in, maybe that's the problem. The only reason I'm asking you to wait is just because if it's not showing here, then maybe you can call back. But hold on, let's see. Was it Malkowski? Okay, got it here. All right, thank you. I'll get to it shortly. Thank you. All right, bye. Good, bye. Okay, so you're, sorry about that. So the reason why I didn't answer that is if I didn't answer it, go to voicemail, then before you know it, they start
Understood,
calling
Judge.
the chief judge and asking why I don't answer the phone. So the question is a simple question, and it's a fair question. Every case that I get, I consider first increasing the conditions of release before revoking conditions because I know it's uncomfortable. I thought about it. I see your criminal history, but I've decided that based upon the allegations, which I understand you're presumed to be innocent, believe me, I completely understand that. I'm not going to just increase the conditions of the new case. Your lawyers can go in front of the judge assigned to the case in division number 19, and they can ask that judge to modify it. In fact, the orders that we sign specifically say that you're entitled to conditions of release once you go in front of that judge. So hopefully you'll be in front of that judge within 3 days. I don't know who's division number 19. Do you know it?
Judge Roche.
Oh, it's
Your
Judge
Honor?
Roche.
Who's that?
Judge Roche, Your Honor.
Oh, Roche. Okay,
Yes,
got it.
and just for the record, just because my client's asking me to, she is in danger of losing her place, which is why she wanted me to ask.
I have to pay my rent Monday.
I-
And I don't have nobody to pay my rent. And I will lose my place. That's all I got. Please don't do this. I would do anything. I don't want to be homeless, Your Honor. Please, I'm coming to the mercy of the court for your help and your sympathy. Please. That's all I got.
I promise you that I consider it, and I understand that every one of us has issues that happen when people are in jail. That I understand that a lot of people are a couple days in jail away from potentially losing their place or losing their job, and there's nothing pleasant that for any judge when we revoke conditions of release.
Yes.
But at the same point in time, we also have an obligation to do what we think is the proper in every case. And it's nothing personal about you. It's based upon probable cause, a new offense, while that other case is outstanding.
Yes, sir.
I mean-
But with this
I hear what you're saying.
is
Right. All right. Were you asking a question? Oh, yeah. All right, thank you. Good luck,
Who
ma'am.
my lawyer is?
It was bond and pretrial release on the new, right? You wanted
Yes.
with PTR?
Right.
$1,600 plus pre-trial release, and he revoked my bond.
And they revoked, yeah, instead of not.
If you could step up to the podium and tell us your name, please. Your name?
Yonel Joseph.
Thank you. The allegations, actually, you were picked up on a capias after you allegedly failed to appear for a status hearing. The bond is $2,000 with the condition of no contact with the petitioner in the injunction. So, just so you know, no contact means no contact at all. There are no exceptions. If you violate the no contact order, it gets you right back in jail. Do you understand?
Okay, yes.
All right. And,
And he's also out on bond, Your Honor,
right.
on the battery DV.
I understand the holding him until IAs, but I don't have the ability to change the
Okay.
use amount. And I can't revoke his conditions of release because it's not a new offense, but I understand you're just
So
telling
taking
me.
no action. Oh.
All right, so you'll be able to post the bond and get out of jail, okay?
Yeah.
Your name, please.
My name is Jorge Chardon, Your Honor.
And your date of birth is February 26th?
Yes, sir.
Okay, thank you. The allegations are that you committed a battery upon a family or household members. That phrase is defined by law. That based upon the paperwork here, I'm looking to see if you qualify for the public defender. You do. They'll be appointed to represent you. I don't see the listed victim here, so I have to order that you have no contact with the victim, that you maintain a separate residence from the victim, that you don't possess any weapons or firearms, and you don't return to the victim's residence except one time with law enforcement to collect any belongings you might have.
What was that, Your Honor? I'm
I
sorry.
understand that the co-defendant is in custody, right? Right, okay. So,
We
so-
don't live in
hold
the
on
same
hold on a
household, Your
moment.
Honor.
Sometimes the notes here indicate whether or not the pretrial services has talked to the victim. In fact, she might be the next person in line.
I believe she is, Judge. She's the next one on the
The
docket.
next on the list, Your Honor.
All right, so, we're only allowed to bring one person at a time? Is that how this works? All right, have her, if the PD doesn't mind standing in the middle, or.
Not at all, Judge.
Yeah, I don't want to put you in danger.
I have quick reflexes. I'm
Very good.
fine.
And they both qualify for PTR too, Your Honor.
Oh, okay, great. Hi there, you Tiffany Morales? Okay. So based upon the paperwork here, you also qualify for the public defender. They'll be appointed to represent you in your case. Now I'm about to speak to both of you all, and then I'm going to ask you a question that I don't want any one of you to feel any threats to get you to say anything other than how you personally feel. I can order that the two of you be ordered to have no contact with each other while the case is pending, or I could allow there to be a contact. I can order you to maintain separate residences, or I cannot have that as a condition. I have to make sure you understand that no contact, you're considered to be more protected than if I allow you to have contact. Because if I allow you to have, I mean, if you think about it, if this paperwork is correct, you were allowed to have contact the other day, and look where you are. So obviously, sometimes people shouldn't have contact with each other, and then other times, this is the paperwork here is just like it represents something that would never happen for the rest of your lives, and you're not afraid of each other, and you'd like there to be contact, and you'd like there to be able to reside in the same place, or be able to at least go to each other's places. Actually, you probably have separate houses already, right?
They do, Judge.
Yeah, okay. So I'll go first to Ms. Morales. Do you want me to order this gentleman here to be ordered to have no contact with you, or do you want there to be some type of contact?
I feel like if he would contact with me, it would be through my mom.
You want there to be only contact through your mom?
Yep.
So they call that third-party contact, all right. So what's going to happen also is whatever I do in one case is going to be the other case. So if I made it as a condition of his release, no contact except through Tiffany Morales' mom, then the reverse would be on your case, you'd be ordered to have no contact with Mr. Morales other than through your mom. It doesn't mean you have to have any contact at all. And as far as I am concerned, you can never talk to each other again. But if you want there to be contact, it has to be through the mom. So let me take this a step further. Sometimes a week or two after court, people start changing their mind and they want there to be more to contact than through the mom. You have to both understand that would require a court to change the condition. You can't get together and agree on the change and make it happen. Obviously, let's use your example for a moment. Let's say, Ms. Morales, you say through the mom, hey, would you like to be able to have contact, complete contact again? He says through your mom, yes, that sounds good. Then one or both of your lawyers would be scheduling a hearing in front of a judge to change it. Because if you all started hanging out before a judge changed it, you're both going to end up back in jail because you both be violating the no contact except through Miss Tiffany Morales' mom. Make sure we're all on the same page here? Yes, Jen?
I don't want contact, Your Honor.
No contact? Oh,
No
even
contact
better.
for me.
All right, so when I say even better, because then there's no confusion.
Yeah, I don't want to risk anything.
Fair enough. All right. So both of you be ordered to have and there's probable cause for both offenses. No contact with each other. Maintain a separate residence from each other. Neither of you are allowed to possess any weapons or firearms. First, I'll ask this question of you, Mr. Morales. Do you have any belongings in her house?
No.
And as far as you know, does she have any belongings at your house?
No. Not
And
that
then
I
I'll
know.
ask her the same thing. Do you all have belongings at each other's house?
Actually, yes. I let him borrow my PS4
Okay.
when he was suicidal. And since he was going through depression, my boyfriend bought me the PS4. And my boyfriend said, let him use it.
So you're saying you have something at his house?
I took the PS4. I still have the remote at his house.
You have the remote of the PS4 at his house?
Yes.
But that's the only thing?
I believe so, yes.
Okay. So you want to be allowed to return one time with law enforcement to collect that one belonging?
Yes.
Can we have our mother go and pick it up, please?
He's gonna have,
Oh, you want to have her mother be able to pick it up? Okay.
Yeah, I'd rather have my
Instead
mother
of the
go and
police.
pick it
Well,
up than to have her come.
Fair enough, okay. So, and they both qualify, you don't have to post any money to get out of jail, you both be on pretrial release. No contact, but your mom, the only exception to the no contact is your mom can contact him to arrange for your mom to get this controller.
Okay.
Okay.
Yes, sir.
Thank you, Judge.
All right, good luck to you both. Now I got the, I wonder why my phone is just going right to voicemail for these emergency.
Did you understand? Child release, you both qualified, no contact with each other. You just have to comply with the conditions of the child release. Don't get arrested or anything else. The child release.
All right, so I got another issue that got called at Orange County Sheriff's
Basically,
Office.
the cases are just dealt with, and eventually someone from their office is gonna call both of them and prosecute each other. And then you want to take a remand.
Hi, it's Judge Mike Murphy calling from court. What's going on?
But we can't go through that, we have to just hire a lawyer, because our office was assigned to represent you, but that granted we assigned to an attorney. We'll end up sending a letter to your house when you call the office.
Ma'am.
No, you're getting out today, just comply with
Fair
the.
Only
Oh,
contact
fair
is
enough.
from the defendant.
All right, I appreciate it.
Just on her
All right,
order,
thank you.
That's
I
what
don't-
it
I don't know why
sounded
my
like
phone
to
is
me,
going directly
yeah.
to voicemail, even though I'm in court right now.
Because she can
If
contact.
I see it ring, I'm
Yeah.
gonna answer it, but all right, thanks. But when you, all right, when you leave voice messages, luckily for
And
me,
then
it
did he
leaves a text
scratch
message.
the no return
All right,
on his?
thanks.
She just said maintain separation.
Just, okay.
Hi there, your name, please?
Kyle Pollan.
All right. You're taken into custody on a KPSO that was issued when you allegedly failed to appear for a pretrial conference. The bond is $2,000, and you're ordered to have no contact with the victim.
Yes, sir.
What?
I'm so sorry for interrupting, I'm so sorry. You guys take me all the way down.
Straight PTR.
I'm so sorry. Go ahead. I didn't mean to interrupt.
All right, so I thought I saw someone's head pop over there. All right, so you're going to be able to post a bond to get out of jail. So far, they've held you at no bond because you had that pending case. But the fact that you have, were picked up on a KPS doesn't allow me to revoke any conditions of release. But now you'll be able to post the bond and get out of jail.
And the bondsman did come off of that case, so
Okay,
he does
slight-
have bonds that he would have to
Slight issue.
bond out on again.
Okay, so what happens sometimes, so you went through a bondsman to get out of jail on that other case?
Correct.
Okay. So sometimes what happens is when a bondsman sees a person get rearrested for something, that bondsman says, whoop, we're off the case. That just means you have to repost the original bond again. Sometimes if you contact the bondsman, they'll just repost it, but that's between you and the bondsman.
Correct. So I still have a bond, right?
Yeah, you have a bond.
Okay. So I can get bonded out today, right?
Yes, unless you got something else that we don't know about.
No,
There's
no,
something
no.
else
I was
we
just
don't know
asking.
about?
Thank you so much. Have a good day.
Okay. Jose Perez, is that you,
Yes.
sir?
Yes, sir.
All right, thank you. All right, so in your case here, let's see. You have picked up an arrest warrant for battery and criminal mischief. I don't see anyone standing up, so that means the listed victim isn't here. All right, so when that person's not here, I have to order the following. No contact, which means you can't have any contact with the victim. No good or bad, no direct or indirect. There's no exception that you can think of because they don't exist. It's easier for me to spend a couple minutes making sure you understand what no contact means instead of have you cause you right back here in jail. So no good or bad, no direct or indirect. You send her $1 million, she'll keep the money likely, why not? But you'd be back in jail because you'd violated the no contact order, okay?
Yes, sir.
No contact with the victim, maintain separate residence, no weapons or firearms, and you're not allowed to return to the victim's residence. Do you have any belongings there that you need law enforcement to go with you to collect?
To be honest,
Just a yes or no?
No.
Okay, so we don't need to put that on there.
I do have one other matter that he just indicated regarding the no contact. They do share children in common, so is it possible to order contact as long as it's in compliance with what I'm not sure if it's a dependency issue at this point or a custody plan.
So,
They have joint custody, he's indicated.
On the warrant says, right there, see the condition said no.
oh, it says no return, no weapons or firearms, no contact with the victim. Oh, got it. So I don't expect that I'm going to be revoking the conditions of release in that other case, but I just want the state to confirm that it's not the same victim. That would change, kind of changes everything. So,
Do you have the case number, Your Honor, from the previous?
yeah, it's 2020 CF 679 AO.
Your Honor, 20 CF 679?
6791
Oh,
AO.
sorry.
I mean, the handwriting on here is much better than mine, but I couldn't tell if that was a slash or a 1, but I think it must be 6791. Arson, attempted first degree murder, petty theft.
Your Honor, I don't have the arrest affidavit in front of me, but I do not believe it is the same victim based on the facts of this 20 CF 679.
But you have the information though, right?
As far as I can tell from the arrest affidavit, it's not, Your Honor. I just pulled it up on the clerk.
I'm gonna wait like a minute to let you look it up, only because the nature of the charges is I don't want to make a mistake with this
Understood, Your
one.
Honor.
Yeah, one moment, Judge.
While he's looking that up, let me just address this children thing.
No, Your Honor, definitely not the same.
Not the same victim, very good. All right, so, I'm gonna ask you a question that's not gonna make a lot of sense while I'm asking it to you but once I get the answer, I'll explain it to you. Or maybe you can even answer it after, wait to hold off, answer it until I tell you why. The question is gonna be, are you married to this person at the time the children were born? That's step one, and if the answer is no, then the next question is gonna be, has a court determined that you are the legal father of the children yet? The reason why I'm saying that is because after being in family division for 3 years, I can't create something that doesn't exist. So it's not that you're treated any different, that you're married to her or not as far as like conditions of release, but it's about my authority to say anything about the kids. So were you married to the person?
No, it wasn't.
And has a court declared that you are the, have you been at a paternity court determination?
No, I haven't.
Okay, I mean, lots of people haven't.
Yeah.
And then other people are listed on the birth certificate as the father, but that actually gives you, shockingly, no rights until you go in court and get a court-ordered determination of time, because the law says that the mother of a child, absent a court order, has 100% decision-making with regard to the child. Okay. Or in your case, children.
Yes.
So no court order paternity determination.
No, sir.
Is there a relative of hers that you know that you think that you could relay information about time sharing, child support, and child custody? Who is that person?
Well, it's my grandmother.
Your grandmother, okay.
She's always at my grandmother's house, but I'm never over there.
Fair enough. So tell me your grandmother's name.
It's Martha Cadwan. Martha Cadwan.
Can you just spell that?
Yeah, Martha Cadwan, Cadawan.
So I'll put in here that it's no contact with the exception of you could go through that person for the purposes of arranging child custody, child visitation, child support. I'm not giving you any rights.
Okay.
Other than what you have, right? So
Yes,
let's say you ask your grandmother to relay a message to the victim that says, hey, I've got $500 of child support for you from my grandson. Can I give it to you? And let's say the victim says, nope, then that's it. She can't force it upon her.
Let it go. Okay.
My grandson would like to see the children. Can you bring the children to me? This is your grandmother speaking, so that I could then shuttle back and forth. Victim says yes or no. I can't force her to do that. Only a family division judge can force someone for that kind of purposes.
I understand.
But there are times where parents want to encourage and foster a relationship between the other parent and the children, and then other times they don't because they don't have to. I have no idea. We'll give this as a small exception. But let's say this. If your grandmother says, he'd like to see the kids and he's really sorry, he loves you, that's a violation of the no contact order. You'll be right back here because you see how I love you and whatever has nothing to do with time sharing, child support, child visitation, child. All right. And if the victim says your grandmother, stop calling me, your grandmother can't call anymore. So.
Okay. Yes, sir.
Thank you, Judge.
All right. And so, all right, so the bond on this case will be $1,500 on count 1, $100 on count 2, and I'm not revoking the conditions of release in that other case. But that doesn't mean the state can't go in front of that judge to try to get the conditions revoked. It's just I'm not.
Thank you very much, Judge.
Right. Back in the old days when I was here, we used to have a little form for that. I was looking for it before I came here, but I don't have it anymore.
You're welcome. Oh, okay. You don't need that.
Hi there, your name, please?
Emmanuel Philippe.
Thank you, and we have someone in the box there. We'll be with you in just a second. Mr. Philippe, based upon actually, we don't have anything here. Can you afford a lawyer, or do you need the services of the public defender appointed to represent you?
Yes.
A little bit louder.
Yes.
I asked you of two parts. Can you afford a lawyer, or do you need the public defender?
Oh, public defender.
Okay, so I'll appoint the public defender to represent you. There's probable cause to believe that you committed a battery on a family or household members. That phrase is defined by law. But there's also a second victim listed. There's a Patino, and then probably this witness here, and then the resisting without violence. So I'm going to ask some questions of this witness here. In theory, you're going to be able to hear it also because it should broadcast on the loudspeaker. To the best of your ability, raise your right hand. You swear or affirm that the information you're about to tell us is both true and correct.
Yes.
Thank you. You can put your hand down and just get a little bit closer to that microphone. I mean, these masks make it difficult sometimes to hear. Can you tell us your name and your relationship to Mr. Felipe?
Maribel Dennis, and I'm his girlfriend.
All right, so you're listed as one of the victims in the case. You've been watching all of these cases this morning. You've heard me talk about no contact and no hostile contact. And anything I would do with regard to you is going to be separate and apart from your Miss Patino. Is that, I think, your mom?
My mother, yeah.
Yeah, okay. So are you asking me to order that Mr. Felipe have no contact with you, or would you like him to be allowed to have contact with you?
I would like contact.
Like him, okay. Would you want me to order he lives somewhere away from you, or are you okay me not having that restriction?
Not having that restriction.
Are you afraid of Mr. Felipe?
Not at all.
If he were to touch you against your permission, would you call law enforcement and report it, or would you be afraid to?
I would call law enforcement.
Right, and all right, so the person directly to your right there, he's with the state attorney's office. The person over there next to Mr. Felipe is with the public defender's office. Sometimes they have questions, sometimes they don't. But I'm
Okay.
gonna ask the state attorney first, and he'll remain seated, or he'll stand up. It's up to him, but he can remain seated.
Thank you, Your Honor. Your one-year-old child, do they live in the house with you?
Yes.
Are you at all worried about the child's safety at the house?
Not at all.
Has anything like this ever happened before with you or your children?
Never.
Was the child there during the altercation?
No, he was sleeping inside.
Okay, nothing further, Your Honor.
Counsel for the defense, do you have any questions?
No, Judge, the court asked my 2 questions.
All right. And you live separate and apart from Miss Patino, right?
Yes.
That's what I thought. All right. So, and does he, he qualifies for straight pretrial release?
He does, yes, Your Honor.
Okay. So, no hostile contact with this witness here. That means no more contact with her than she allows you to have. You could have no contact with her if you want to, but no hostile contact with her, which means if she says, don't yell at me, you can't yell at her. Got it? Yes. Now, with regard to Miss Patino, it's no contact at all. No good or bad, no direct or indirect. If you ask the daughter to relay a message to the mom, that's a violation of the no contact order. Just no contact at all. Got it?
Got it.
All right. So maintain a separate residence from Miss Patino. Don't go to Miss Patino's house. You don't have any belongings there, do you?
No.
I didn't think so, but just want to be sure. And then you'll be released, pretrial release on both counts with those conditions that I mentioned. That means you don't have to post any money to get out of jail, but if you violate the conditions, it'll cause you to be right back in jail again. Make sense?
Yes.
All right.
You got no hostile contact with one, excuse me?
Yeah, there's 2 victims, although there's only 1 charge, but there'll likely be 2. I mean, it could be 2 later. So it's no hostile contact with. Oh. Should have highlighted it. It's, well, let me put it this way. It's,
I think you said no hostile with Mary Bell Dennis, Your Honor?
right, there you go. It's no hostile contact with Miss Dennis and no contact with Miss Patino. I was just trying to look for the, Tina is the first name of Patino, and as the prosecutor said, Maribel, Denis, is the no hostile contact. All right, thank you all. Hi, are you Dwayne Pryor?
Yes, sir.
The allegation is you committed a battery upon a family or household members. That phrase is defined by law. And now we're about to set conditions of release. The listed victim isn't here, so I have to order at least that you have no contact with the victim, that you maintain a separate residence from the victim, that you don't possess any weapons or firearms, and that you don't return to where the victim resides except for one time with law enforcement to collect belongings. You'd contact the sheriff's office, tell them you're allowed to return one time, and there's a procedure that they'll have you follow. And then you're not allowed to possess or consume any alcohol. Let's see, does he qualify for straight pretrial release?
Yes, Your Honor.
All right, you won't have to post any money to get out of jail. But if you violate any of these conditions, it's going to cause you to be right back in jail again. Do you understand?
Your Honor, we live together. We
Not
just
anymore.
moved here from St.
Not while the
Louis.
case is pending, though.
I'm sorry?
While the case is pending, you can't live with her.
So what am I supposed to do?
Well, some people choose to remain in jail if they don't have any other place to go. Other people choose to stay at a friend or family member's house. Other people choose to live on their own somewhere differently. You have to decide what's in your best interest, but what you need to know is that you're not allowed to have any contact with her while the case is pending, and you're not allowed to return except for one time with law enforcement to collect belongings from where she resides. Does that answer your question?
Yes, sir. I was just trying to let you know that she lives with my grandmother. We just moved her from St. Louis, Missouri.
Yeah, so I don't have, what happens is, it's these cases are like state of Florida versus Dwayne Pryor. I don't have the ability to make her do anything.
Okay.
But I can put restrictions on people who are accused of crimes, even though they're presumed to be innocent.
Yes, sir.
So, now what sometimes happens is people's lawyers file motions in front of the judges assigned to the case, and they bring people into court to testify, and the judges later modify the conditions. But right now, it's the no contact and no return, okay? And maintain
Yes, sir.
separate residence, and the other things I said. All right, good luck, sir.
Yes, sir. Yes. Yes, ma'am. I mean, I'm sorry. Oh, okay. Okay.
I'm
Yes.
sorry, Judge, were we appointed on that case or no?
Yes.
Oh, we were.
Hi, your name, please?
Roxbury Sales.
Thank you. The allegations you committed battery on a family or household members, that phrase is defined by law. I have to order that you have no contact with the victim, that you maintain a separate residence from the victim, that you don't possess any weapons or firearms, and you don't return except for one time with law enforcement to collect your belongings. You qualify for the PD, so they'll be appointed to represent you. It looks like you qualify for pretrial release, so you don't have to post any money to get out of jail. Make sure I read that correctly.
Yes, Your Honor.
Okay.
He does qualify.
And there is probable cause. So you don't have to post any money to get out of jail, but if you violate any of those conditions, it'll cause you to be right back in jail. And just to be clear, no contact really means no contact. If you're thinking, oh my gosh, I got an exception to the no contact, that sounds like you're just getting back in jail. There are no exceptions to the no contact order, okay?
I'm filing my divorce to don't have no contact, period.
There you go.
Here?
Yeah, nothing wrong with that.
I have a question. How soon, as far as when would I be able to get a law enforcement to be able to pick up some things?
So what happens is when you get out of jail, you'll contact law enforcement on the non-emergency line.
Okay.
And you'll say, I have a court order that allows me to return one time with you all to get my stuff.
Okay.
What do I need to do, is what you'll say, and they'll tell you the procedure. If you go directly to the property, you're just gonna get arrested. Don't go directly to the property. They'll meet you away from the property.
Okay.
And then before you rent like a U-Haul or anything, make sure you find out what you're allowed to get. Sometimes people are allowed to get, have hours worth of stuff to get things. Other times they say you're only allowed to get a very few items.
Okay.
So make sure you understand. So let's pretend they say to you, you're only allowed to get a toothbrush. They better not say that, but let's say they said that. You don't argue with them. You say, thank you. And then you call your lawyer and you go, hey, we need to go in front of the judge assigned to the case and see if we can get a list of items that I'm allowed to get, because just a toothbrush seems kind of ridiculous.
Okay.
Fair enough? All right. And then because we've had cases before where the victim says all the male clothing are mine. And you're like, that's impossible. But anyway, so sometimes that happens. So that's when you go in front of the judge and have to get that all sorted out. But today, it's just you're allowed to return one time with law enforcement to collect your belongings. And I promise you, when you call them, you won't be the first person that calls them with that issue. Non-emergency line. If you call 911, you're going to have another problem.
Okay.
All
right, thank you.
Yes, sir. Good luck. All right, your name, please?
Deron Brantley.
Oh, here it is. All right, so, sir, on your case here, you qualify for the public defender's office, so they'll be appointed to represent you. You were taken in custody for a warrant for your arrest for robbery with a firearm, as well as aggravated battery with a firearm. It looks like you might have might have little or no criminal history other than maybe something in a juvenile. When it says one felony, is that the juvenile thing? Is that how, I want to make sure I'm reading this correctly.
Yeah, it's a juvenile conviction.
Okay. All right, so in this case here, you're ordered to have no contact with the listed victim. Not allowed to possess any weapons or firearms. On the aggravated battery with a firearm, the bond is $2,500. On the first count, robbery with a firearm, even though you have no prior criminal history, significant, you only have that one grand theft, which is pretty much nothing. Although I'm sure the victim of that case probably wouldn't say that. But I recognize you have no prior significant criminal history, but on count one, based upon the allegations in the affidavit for arrest warrant, which I know are just allegations, there hasn't been a hearing to establish whether it's true or not. They're going to hold you at no bond, but the state's going to have to prove in front of a judge at an Arthur hearing within a reasonable time that the proof evident and presumption great exists. If they don't do that, then you're entitled to bond on that case. But I don't know if you've had I'm not asking you to comment about this, but when you get a chance to eventually read the affidavit for arrest warrant, you'll see why it is that if I have to believe that the report is true, why I would be holding you at no bond, at least until you have a hearing, so that your lawyer would be able to challenge and cross-examine the evidence against you. And proof evident presumption great is even higher standard than beyond a reasonable doubt. Oh, and then let's see, well, he's been held no bond, so.
So you want to take that off?
Yeah. And then I have to order the no contact, though, with the victim.
Yes.
All right, thank you. Next case is Calvin Bronson. All right, so you're Mr. Johnson? All right. You qualify for the PD. They'll be appointed to represent you. There's probable cause to believe that you committed the offense of criminal mischief in an amount of more than $1,000. Let's see what this says here. So you all haven't had a chance to interview him yet?
No, he was never interviewed, Your Honor.
All right. So your bond on the case is going to be $1,000, and don't return to the Save Discount store, okay?
I have a question. Is there some way I can...
Ask your lawyer the question so you don't hurt your case. Was she able to answer your question?
Yes, Judge.
Okay. Yeah, not a playable case if that was the question. Hi, are you Tracy Edwards?
Yes, sir.
All right, thank you. You were already at the jail. They realized that there's another capias for your arrest in a different case of a burglary, criminal mischief with damage of $1,000 or more, 2 counts, a resisting officer without violence, and a petty theft. A capias was issued when you failed to appear for court on January 7th, probably because you were here at the jail. But somehow your lawyers might not have brought that to the attention of the judge. What is the other case that he's in jail on?
Yes, was a trespass. Is it on? I believe he's scheduled to be heard on that today as well. It was a new law offense of a trespass.
Did he have on this case, though, this felony case, he had the public defender's office representing him already, right?
Yes, Judge.
And don't you, before the judge issues a capias, don't you all look on the jail roster to make sure that the person's not in jail?
We usually do, Judge. I'm not sure.
I know it wasn't you, I'm just...
Yeah, I'm not sure what happened here.
There's this website called vinelink.com that you can look over the entire state just to make sure. But
We do use that, so I'm not sure what happened here.
anyway, so hopefully your lawyer can get in front of the judge assigned to the case this week to get you a bond again. Are you able to email the public defenders in that division and let them know that?
Absolutely.
All right, so. I mean, maybe because I could, normally I'm not allowed to address capias, but maybe I can just reset it for this Tuesday coming up, and maybe you can all, if he's still here, have them address it here at IA's in front of the IA judges, because if he, because the jail would be able to confirm that, and then you all would be able to get in front of Judge Roche, maybe even get the next court date that he can just be given right here in court.
We do have, I am showing a court date on January 19th in Roche's division.
January 19th? That didn't get canceled when he failed to appear?
No, I believe they listed as an arraignment, but it might be determination of new trial dates since he picked up since he had the KPS, got arrested on the KPS.
So
Sometimes-
don't reschedule it for anything?
At this point, actually, if you wouldn't mind, Judge.
Okay, just set it for Tuesday just to make sure that he has the next court date in front of Judge Roche.
And then are you
Hey,
saying
are you here normally? Are you here during the week?
I'm with Lattimore.
Oh, okay. Well, lucky you. Lattimore now on her new assignment.
Yes.
Okay, great.
Which was Judge Whitehead.
Right on.
Jerome, do you have a new trespass charge for him too?
Huh?
Do you have a new trespass charge for him too?
A
I'm
new
showing
trespass?
that he was arrested on a probable cause trespass.
Unless that's,
Oh, so he what? wait a
Yeah,
minute.
he was just brought in yesterday on a trespass.
Oh, so he wasn't in jail on January 7th? Okay,
No,
then don't
he was
reset it for
not.
Tuesday.
He was brought in on a trespass new law.
Got it, okay. Do you have a copy of that we can make so?
I don't have the affidavit. It's in the system. I can,
you have a case on?
sure. It's 2021 MM 000 AO.
How much is the bond?
It was set at 500.
And he hasn't had an IA on that yet?
No, that's why I said he also has to be seen on that trespass as well.
So do you have an affidavit?
I can print it out. You need me to print it out for you?
Yeah, because I don't have it.
So who stamped that as an add-on charge?
It's not?
No, the last one we just did was an add-on.
Stamp the add-on? Oh. Oh, is it?
How about this? Lean against that back wall. We'll be with you in a moment. You have one other case we want to address.
I'm trying to print it, but the printer's not.
I just sent it to Nadia after they sent it to me.
Sure. If you just take one step back, we'll be with you in just a moment. You have one other case. Hi, are you Jay Hancock?
Yes, Your Honor.
All right, you're in custody on a possession of cocaine and a possession of drug paraphernalia. You qualify for the public defender's office. They'll represent you. There's probable cause to believe the offense occurred. And let's see. So he doesn't qualify for pretrial release?
No, Your Honor.
All right, so your bond is 1,000 on count one and 150 on count number two, okay? The next case is going to be Mr. Hayes.
And I'm sorry, were we appointed on that one?
Yes,
Judge?
ma'am.
Okay, thank you.
Hi, are you Ted Hayes? All right. There's probable cause to believe that you committed petty theft with 2 prior convictions. You qualify for the public defender. They'll be appointed to represent you. And as I said, there's probable cause to believe the offense occurred. And let's see, your last conviction, it says, if this is correct, was in October of 2020. Therefore, your bond is going to remain $1,000. And no return to J.C. Penney's, okay? All right, thank you. Next case is Prince Johnson. All right, so Mr. Johnson, there's probable cause to believe that you possessed alprazolam and possessed MDMA. You qualify for the public defender's office. They'll be appointed to represent you. And I'm not going to revoke the conditions of release on that case that you're out on bond on. I'm just going to increase the bond on the case that you currently have. Their bond is going to be $5,000 and $150 on count number 2. Do you understand? You'll be able to post a bond and get out of jail?
Your Honor, I just found out this child was mine. I already have 9 kids. Yeah. And I do work, you know, but right now, I might need you. Can you help me, please? I'm the only worker in the house. Like, you know, they depend on me, please.
I don't understand the question. So I did not revoke the bond.
Yes, sir.
I just gave you a bond, though. So now you can post the bond and get out of jail.
Okay.
If you can't afford to post the bond, then your lawyer can go in front of the judge assigned to the case to try to get you a lesser release. But, I mean, people post this, they give $500 to a bondsman and they're out of jail on a $5,000 bond.
Yes.
So. And in fact, your bond amount on the other case, if this is correct, is at $12,000 for the one that you, if I read that correctly, or maybe it was $2,000. It's hard to read the handwriting, but still better than mine.
Yeah.
All right, so the good news is I didn't revoke the conditions of release. The bad news is maybe you can't afford to post it, but we won't know until you try.
Okay.
All right, good luck, sir.
Yes, sir. Thank you.
What's that? Oh, got it. Yeah, maybe. Tracy Edwards, we got the form here again. Did the PD in state have it? Otherwise, we might have to print it 2 more times. Well, I mean, it's a pleable. I mean, there's probable cause to believe that the trespass occurred. The question just is, do you want to hear a plea offer? It's he's still going to be held on that other case, whether he takes a plea or not.
I think if he's, well, he's indicated that he would like to hear a plea offer from the state if they're so inclined.
Your Honor, the state's offer in this case would be an adjudication of guilt, credit for time served, no return to the scene, court costs, cost of prosecution, Your Honor.
Okay, so you'd be released from, at the end of the day, you'd be released from this case, but don't forget, you still have that other case pending that you're going to...
Yes, sir.
You want to accept the plea offer, or you want to turn it down?
He wants to accept, Your Honor.
All right, so if you enter a plea of guilty or no contest to the trespass charge, you'd be adjudicated guilty, sentenced to 2 days' time served. You'd be released as to that case only, and the financial obligations will give you 1 year to pay. But then there would be no trial. Your lawyer wouldn't be able to challenge and cross-examine the witnesses and evidence against you. You wouldn't be subpoenaing witnesses to testify on your behalf. You wouldn't be able to testify or remain silent because there would be no trial. Do you understand you give up all those rights if you plead guilty or no contest?
Yes, sir.
Has anyone made any promises or threats to get you to enter any type of plea here other than the sentence that I told you'd receive?
No, sir.
To the allegation that you committed the trespass on property after warning, you plead guilty, not guilty, or no contest?
No contest.
It means you don't admit it, but you don't deny it. You want to get sentenced. Are you entering this no contest plea because you believe that's the best way to resolve the case for you?
Yes, sir.
All right, I'll find that you knowingly, freely, and voluntarily and intelligently waived your constitutional rights with an understanding of the nature of the allegations and consequences of the plea, and there's a factual basis to accept the plea, and I'll give you the sentence that I told you to receive. Do you have any questions?
No, sir.
All right. Good luck, sir. Thank you. James Leon? Are you Mr. Leon?
Yes, sir.
All right. You're taken in custody on arrest warrant for burglary of a dwelling and grand theft 3rd degree. Let's see here. Do you all know how long ago his out of state happened?
I can try to check quickly, Your Honor. Let me.
Right. So I see you said you didn't have any?
I'm pulling it up now, Your Honor. I just had to run the history quick. That conviction occurred in 2009.
Okay, so your bond on the count number 1 is going to be $5,000. The bond on count 2, $1,000. No return and no contact with the victim. All right. Do you understand?
Yes, sir.
All right. Thank you.
Your Honor.
Next case, Sabrina Petty. What happened? Oh, wait, I see. I skipped someone, sorry. We'll come to you in just a moment, sorry. The paper clips, I grabbed the wrong case. All right, so that's all your case, sir, and now I'm going to go on to Skyla.
No, you're good.
Skylar McGow has bonded, Your Honor.
Bonded, okay.
Charles Muse has also bonded.
I did that again. All right, Christopher Nahart. All right, thank you. Taken into custody of a burglary of a conveyance and possession of drug paraphernalia. Give me just a moment to get your paperwork here. There's probable cause to believe the offense occurred. I see the prior criminal history. All right, your bond is going to be $1,000 on count 1 and $250 on count 2. Do you understand?
Yes, sir.
Right, thank you. Sabrina Petty. All right, thank you. The allegations are you committed an aggravated assault with a firearm and also possession of a concealed weapon. And now I'm about to see whether there's any prior criminal history. Let's see.
And she does qualify for PTR, Your Honor.
All right, so there, as I mentioned before, there's probable cause to believe offense occurred. The bond is going to be $2,500 on count 1, $150 on count 2, plus pretrial release with the condition, don't possess any weapons or firearms, and no contact with the listed victim. Do you understand? No contact means no good or bad contact, no direct or indirect contact, okay?
Can I ask a question, Your Honor?
You can ask it to your lawyer first. I wanted you to make sure you don't say something that'll hurt your case.
Am I able to get ROR or a lesser bond?
Well, it's a
serious,
question that I'm going to answer the best I can. The answer is, legally, I could give you a lesser bond, but I read the report. I saw the priors, which aren't really that bad of a priors at all. It looks like they're misdemeanors only, and even though there's some failures to appear and even VOPs, in the grand scheme of things, these aren't that serious. But there's some, and I know the police report isn't necessarily what the state could ever prove, but there's some allegations, including words like kill and so forth. Not that I want you to comment about anything about that.
I know.
But those are things that I have to consider when I set conditions of release, and the failures to appears don't help you. So that's why I said it. So
Okay.
your answer to your question, honestly, is do I have the ability to give you a lesser bond? The answer is yes, but I don't feel comfortable doing it, and that's why. That's right. All right, thank you.
Thank you.
Chris,
You said count 1, Judge? I'm sorry. What was the bond for count 1, Judge?
2,500.
25. Thank you, Your Honor.
Thank you.
All right, next, gentlemen, step on up. Tell us your name. Your name, please?
My legal person name is Chris Philippe, but that's not my actual name.
Okay, what's your last name?
My legal person's last name is Chris Philippe.
There's a sound here that makes it sometimes hard to hear. Tell me, you say your legal last name is what?
My legal person's name on a social security card and birth certificate, the last name is Philippe, but that's not my last name.
Okay, so tell us what your other last name is.
No, I'm just a man.
Once more?
I'm just a man.
Just a man?
Yes.
Okay. Sometimes I think it's just the sound. It sounded like you said just a man.
Yeah, I'm a man. You know, I was threatened, and you know, to use the legal person's name.
But if your mom was talking to you, she was saying, "Come on over for dinner." If she saw you over there and she said,
Now, she calls me something else. She just
all right,
that's
fair
not,
enough.
that's
We'll
not my
probably
that's
pick
not
the
my
wrong
actual.
person.
That's my legal person's name.
Okay. Thank you, sir. The allegations are that you possess methamphetamine, that you destroyed evidence, that you resisted without violence, and you possess drug paraphernalia. Those are the allegations. That doesn't mean the state could ever prove it.
Yeah. Yes, sir. Yes, Your Honor. I was illegally stopped. I had all my lights on my bike. You could look at the video body cam, and I don't have a public defender.
Yeah. So, you don't want the public defender's office to help you?
No,
Okay.
I have nothing to hide. You feel me? I was illegally stopped. I had lights on my bike, and the officer said I didn't. And you can look the body camera, and then I tossed my cigarette away, and he says that I tossed something else. And then next thing you know, he's arresting me, and then he's looking through the yard and someone else's property, private property, and he's placing things on me that I didn't even see, that I had no possession of. If you look in the affidavit, it said that he did not find anything on me, and then he's saying that I did not have back red lights. But if you look on the body camera, I had lights all over my bike. Yeah.
Fair enough. When it comes to initial appearances, even if the police officer wrote in the report, I illegally stopped the defendant and discovered in his pocket marijuana, the IA judge would have to find there's probable cause to believe the crime occurred, because they don't do suppression motions as part of the IA, as unfair as that might sound. So even if, like I said, even if the police report said, I illegally stopped the defendant, I couldn't even consider that for the purposes of probable cause.
You see, my thing.
Hold on a second. Once you post the bond in this case, which we're going to talk about in a moment, apparently Valdosta, Georgia has a, oh no, they have, this is pickup in Georgia only for some crime up there. But that looks like it's just a traffic, what we call civil, on a driving while license suspended. So that's just they won't pick them up here in Orange County.
That's
Yeah.
correct, Your Honor.
You're right.
It'd be
Okay.
just in Georgia.
But that just, okay, let's see. All right, so I understand what you're saying. So, but your bond on this case here, based upon you having some prior felonies and misdemeanors, including the convictions, that your bond is $1,000 on count 1, and then $50 on counts 2, 3, and 4?
You said $50?
Yeah.
You know, but I would just state those things for the record that on a police affidavit himself, he says that he did not find anything in my possession, and that he assumed that I threw something away, and he went and searched someone else's property. He was stopping me for a traffic violation, which do not apply to me because I'm a man. I'm not a legal person. And then on top of that, you know, like I said, he using the probable cause that I did not have lights on my bike, and I had lights on my bike. So you can look in the body camera for evidence, and then, you know, that would open doors for a lawsuit or whatever the case may be, you know. So he did, and he says it's on the affidavit that he did not find anything in my possession, and he assumed I threw away something, and he found something else on someone else's property, and he's trying to say it's mine, you know. So that don't make sense, you know. And I was minding my business. I was riding my bike on the sidewalk, and I had lights on my bike, and he says that he had body camera on his person. So I would like, you know, that to be, you know, put into evidence. I would like for it to be viewed immediately, because then that would mean, because then if it's true that I did have lights, and then I'd be mean that I was kidnapped and I was threatened, you know, and that's a very serious matter that should be addressed, you know, immediately, you know.
There's people that sue law enforcement officers all the time. So, but you in your criminal case, you'll be able to participate in discovery if that's what you ultimately want to do, including getting the body camera. But that's not for today.
Yeah, but I was just saying that for the record that, you know, I was kidnapped, and I think that if anybody was kidnapped or, you know, being threatened by firearm or and falsely accused, and then if the court has access to those type of things to find out immediately, then I think it should be done, you know, because if it was anybody else, life was being threatened, and then they're feeling, you know, and then they're being kidnapped and forced into a position that they're not supposed to be in, I think it should be addressed immediately, you know. That's like an emergency thing.
And you don't want the public defender to help you, right?
No, because I'm a man, you know. I'm not a legal person, and I'm truthful and honest, and you know, and I feel like I should be R&R for the time being. I shouldn't have to come out the pocket or anything, you know. You know, especially when the guy is saying, the Caucasian man is saying that, you know, he observed me riding with no lights, and that was his probable cause. And then he said he did not find anything on my person, and that he went on someone else's property and found whatever he found, and then trying to lock me up, you know. So, and I was kidnapped, you know. I was put at gunpoint. I was, you know, I'm in fear of my life, you know. So, you know, that's not cool, you know. I think any human being would not like that, you know.
I understand what you're saying, but today is not the day to address all of those other matters. But everything you said has been recorded, and so you said for the record, so you know how to do that. And then hopefully you'll be able to, in representing yourself, you'll be able to get the evidence that you want.
I don't plan to represent myself, Your Honor. I am myself.
You are yourself. Fair enough. Okay. Good luck, sir. Thank you.
Thank you.
Gentlemen, step up and tell us your name, please.
Hi, Your Honor. My name's Daniel Rovello, sir.
All right. So you have 3 different cases here. You have a case where they arrested you on an on-view violation of probation. Then you have a felony new case. And let's see my handwriting. Oh, then you have a new, okay, I got it. So you have a new traffic case, which is a criminal traffic. You have a new felony case, and then you have the on-view VOP. Can you afford an attorney, or do you need me to appoint the public defender? Public defender?
I'll try to afford an attorney, Your Honor.
Fair enough. Do you, if you ultimately can't afford one, you can always ask the judge the next time to give you a lawyer. So you have, on the possession of a firearm by convicted felon, there's probable cause to believe the offense occurred. And on the possession of ammunition by convicted felon, there's probable cause, although ultimately, if I'm not mistaken, he can't be convicted of both, but we're here at probable cause determinations, not the trial. And then you also have the operating a motor vehicle without a registration.
Yes.
What's that?
Yes, sir. I was pulled over.
Yeah, hold on. Don't help the state unless that's what you're trying to do. And then the on-view VOP.
He's also got a driving while license.
Oh, the next one. Okay, the driving while license suspended with knowledge. Okay, got it. All right, and then there's the driving record here. All right, so there's probable cause to believe the offense has occurred. And let's see, prior criminal history. Fair enough. All right, so it's just not checked off. That's all right. All right, so he filled out the affidavit and he qualifies for the PD. If you hire a private attorney, they can always take over for the public defender's office.
I just need help to get out and
Yeah.
be with my kids. Is there any way I could bond out? The firearm was my baby mother's.
Yeah, but you probably don't want to help the state too much in their prosecution of your case. Because with regard to the driving while license suspended, no registration, the bond is each $500. On the possession of a firearm by convicted felon, the bond on count 1 will be $2,500, the bond on count 2 will be $150. But it's that on-view VOP that's going, because there's probable cause, the on-view VOP holds you at no bond. But if they don't file a violation of probation on you shortly, then what happens is at your next court date, they likely just dismiss the VOP without prejudice for them to file an affidavit. Because right now, all that's happened is a law enforcement officer believes that you're on probation, had probable cause to believe that you committed a crime while on probation, so that's what the on-view VOP is. But it's not a VOP filed by your probation officer. They'll have an opportunity to do that if they wish. But if they don't, then they won't be holding you on that much longer.
Okay.
He also has a first appearance detainer, Your Honor.
Oh yeah, so I'll release the first appearance detainer.
Okay, so you're taking no action on it?
Right, he's being held no bond on the VOP, but thank you for asking.
How much is the bond amount on count 1, Your Honor?
$2,500 and $150. And then $500 on the traffic cases. Each case, $500, $500. And the felony case, $2,500 count 1, $150 count 2.
Thank you.
I feel like the stack is bigger now. Yeah, so most of these, they haven't been checked. That's right. No, it's not right.
Thank you, Your Honor.
Yep, good luck. Corey Roberts is the next case. Do you qualify for the public defender, Mr. Oh, wait a minute. Hey, Mr. Roberts, you qualify for the Public Defender's Office. They'll be appointed to represent you. A judge issued a capias when they believed you didn't show up in front of them the other day, and they set the bond at no bond. But it says that they'll give you a bond when you go back in front of that judge. And then they held you also on a first appearance detainer because of your petty theft case, but that detainer will be lifted. So the case is in division. Division. Oh, Judge Roche, she's getting a lot of work today. So your attorneys can go in front of Judge Roche and she'll give you a bond. She just wants to see you. All right.
Okay.
So now your attorneys will be able to schedule that hearing in front of her. Okay. Thank you. All right, your name, please?
Anthony Scrivens.
All right, thank you. You're here today based upon a possession of meth, or MDMA, possession of cocaine, and possession of drug paraphernalia. All right, there's probable cause to believe the offenses occurred. You'll qualify for the public defender. They'll be appointed to represent you. The bond is $1,000 on count one,
They-
$150
they
on
do
count two,
qualify
and
for pretrial release, Your Honor.
What's that?
They do qualify for pretrial release. The defendant qualifies.
This defendant right here?
Yeah, for pretrial release.
All right, so you can either post the bond or be released on pretrial release. Both options are available for you.
So bond or, Your Honor?
Yeah, bond or, and if you're on pretrial release, you'll be subject to tests to make sure you're not possessing or consuming any drugs that are not lawfully prescribed to you.
So RUAs only if they're on pretrial?
Yes, yes. Thank you. And any positive test or refusal to take a test is a violation, okay? All right, thank you. Robert Smithers is the next case. All right, Mr. Smithers, you have two cases. There was a case where you failed to appear for court, and the judge set the bond at $2,000, and then you had a grand theft charge of a motor vehicle where the bond is $2,500. The Public Defender's Office will be appointed to represent you on these two cases. Do you understand?
Yes, sir. Yes, sir.
All right.
And
Well,
then,
the clerk might, maybe got another case.
Yeah, on the traffic case, Your Honor, the failure to appear, that KPS was quashed, so if you could be ROR'd on that.
This one here is, this one here. Here's the order showing that maybe partial. He got arrested, so we just need to release him. This one.
All right, got it. So on 1274, that case,
Yes.
the judge quashed your capias, and you have a court date on January 19th at 10 a.m., and it's a virtual hearing. You'll get a copy of this paperwork, right? You all give him one when he leaves, or no? Well, when you get out of jail, you're gonna bond out today?
I'm gonna try, sir.
Make sure, if you don't get a copy of, well, let's see if he, maybe he already has the public defender in that other case. Oh, your email address is robertsmithers@358@gmail.com?
358, sir.
All right, so they already have your email address. It's your responsibility to contact the JA at least 2 business days prior to your hearing to confirm we have your correct email address. So, anyway, so your bond is only going to be,
So on this one, you.
That was
I mean, releasing him on this.
right,
Okay, and then he has his misdemeanor case right here.
right.
What you did for one, you got 3 cases. Excuse me. You did this one, and then this one, release him on this one, and then that's this one.
Fair enough. And apparently you have a third case here, and let's see, of course, this doesn't list that he's got 2 prior convictions for theft, but let's see if this does. Oh, they changed it to just petty theft, first offense, $500 bond. All right, so I don't know who changed that. Oh, got it, okay. So your petty theft charge is probable cause, and the bond is $500 on that case. That's 21 MM212. That's the one from Walmart, and don't go back to Walmart. Then you had the case that we addressed and realized that they had revoked, the capias was quashed, so you don't have to post a bond on 1274. And then you have the third one, and the bond was $2,500 for the grand theft. All right, got it? So the
Yes.
total is 3,000.
$3,300.
Either your name, please? Are you Timothy Wilson? Okay. Okay, I don't understand this one. So he was arrested, they posted the bond, so they didn't get to see an IA, then they came off the bond, and
Yeah,
so now we're having,
They endorsed his bond, so now I guess
where's he
he's
been
being-
for the last week? Wait, if someone just endorses the bond, they
He's
see a new
he's been here since January 5th.
fifth?
But they came off of this CF 27AO bond.
So every time someone comes off the bond, they have to do a new IA? A question, I'm just curious.
I don't know if he was ever IA'd on it,
Oh, because he bonded out.
because he bonded out, so now he has to be brought before the judge.
Okay, got it. All right, can you afford a lawyer? Do you need the services of the public defender?
I would appreciate the services of a public defender.
All right, they'll be appointed to represent you. Have you been unable to post the $1,000 bond since you got brought back?
The $1,000 bond was revoked or rescinded. I didn't know about that until a couple of days ago.
Okay, hold on. Is this, I'm asking this question to the jail, although I'm looking kind of in your direction. Is this the only case holding him in
No,
jail?
he's been on another case as well. He was already IA'd on that other case.
So
Okay.
after
So what's the bond conditions on the other case?
The other case, the bond total is 30,000. I'm not sure what the,
You have the case number?
yeah, the other case is 2021, or 2020, CF 00, or 2021 CF 000201 AO.
And, okay.
201 AL?
201 AO.
So no judge has revoked the conditions of release. The bondsman's like, well, he's in jail, might as well just come off the bond, is basically what's happened.
The
And then
bondsman came off of it, yeah.
Okay, and then because he never saw a judge for IAs, or saying, okay, let's
Right.
go do the IA.
Now he's been brought before.
All right. So your bond in this case is $1,000 plus no contact with the child, don't possess any weapons or firearms, and you'll be supervised by pretrial release on
Well,
this case. once you-
that charge does not qualify, Your Honor. We couldn't release him pre-trial release.
Even with a bond?
Yeah, no, that charge doesn't qualify.
Right. So post the bond, you get at it, hold on. You have that other case. I'm not worried about that other case for now. I'm just talking about the child abuse case. You have to repost the $1,000 bond. And then it's no contact, don't possess any weapons or firearms. Got it? Yeah, I have no control over what's going on in that other case. Hi there, your name, please. Step on up to the podium. Yeah, how do you pronounce your name, please?
Samuel. It's like Samuel with an I.
I must have the wrong case here.
Your Honor, Zachariah Lafrane
Yeah.
is behavior.
Okay, there you go. Clearly, that doesn't sound like your name. All right, so that case will be reset for,
What about Johnson? Did that one, we skip Johnson?
Johnson was done already.
All right, so we'll reset last name Lafreniere for Monday. Yep.
George Lee is mental health.
George Lee, mental health. George Lee. On George Lee, yeah, we'll reset that for Monday. There is probable cause to believe the offense occurred. The bond is $500. Reset it for Monday. And then, okay, next one.
I'm sorry, I got a little confused, Your Honor. We just passed over Lafreniere and now we're on George Lee?
Well, yeah, George Lee is not here because of a mental health issue.
Okay, so we passed over 2 and now we're on,
And then the next one I have here is looks like Pedro Morales Caesar, unless I handed too many cases to the clerk.
yes, did we skip that one as well, or that's now?
Yeah, we don't have him on the docket.
Do you have a booking number for him, Your Honor?
Sorry, Judge.
No, it's all right, I just,
What's your number?
it's 672.
672.
Yeah, but that's not this
They-
gentleman.
they
This
bonded.
gentleman. Oh, I got it, okay. So Caesar Pardo Morales bonded out.
Yeah.
How about this? What's the next? Then I have, the next one after that is Frankie Vasquez. Did Frankie Vasquez bond out?
Do you have a booking
Okay,
number?
I see what you're saying.
For,
So they need the 693. 693 bond out?
they bonded.
Okay. So are we all, everyone on the same page?
Yes, Judge.
Or are you still missing some? Who's the next one in your stack?
So we passed Lafreniere, we passed Lee, we passed Pedro Morales, and we're passing Frankie Vasquez.
Right,
So then,
because they bond, Vasquez bonded already.
so then I have Culp next.
Yeah, so this is that gentleman. All right,
Okay,
thanks.
thank you, Judge, my apology again.
No, it's, all right. So now we're entering the pleable section. You're charged with resisting without violence. The state may make a plea offer to you. If you don't take the plea offer, looks like you might, well, I thought I know how to read these, but does he qualify for a straight pretrial release?
No, Your Honor, he was not interviewed.
He's what?
He was not interviewed.
Oh,
He
not
was
interviewed, so he might qualify for pretrial release.
You could give a bond or if you wanted him to be.
It says
yeah,
no
interviewed,
prior
Your Honor.
criminal history, so. So you want to hear a plea offer, or do you want to, because what happens is, I'd have to say it's bond of $500 or pretrial release if you qualify. They still have to interview you, and I don't know what you might say during your interview. Obviously, some people have good interviews and some people have bad interviews. If you have a good interview, then you won't have to post a bond to get out of jail. Some people, they want to plead to the charge and just move on with their life, but you have no prior criminal history.
No, sir.
Maybe you're not that person.
This is my first time.
Yeah, so maybe you don't even want to take, because the state might, you get out of jail, the state might offer you diversion and the charges get dropped later.
Okay.
Oh, the clerk just told me you might have more than one case.
Yeah, Your Honor,
Yeah,
I
it's
have
three
3 cases for this defendant.
Oh, they're not even going to make a plea offer to you.
No,
because
Your
one
Honor,
of them
there
is
was
an
no offer
assault.
at this time.
Well, it does say 1 of 3, 2 of 3, 3 of 3. You got to blame that one on me.
I think it's my fault, Judge, I got everybody confused.
No, this is all me. I mean, there's no way you don't just take the pretrial release if you qualify and see if you get diversion, although that's your decision, not mine. So the bonds would be as stated on the docket or pretrial release if you qualify. So, I mean, I don't know what they offer diversion for anymore. I don't know if they'd even offer for an assault, but you might as well at least try to see what's out there.
Any conditions?
What's that? Oh, good question. Why not to order no contact, so I'll tell them that.
And are there any conditions with any of these
Thank you. So, sir,
cases?
yes, sir, so it'd be the bond or pretrial release if you qualify. They're going to be with you. They ask you a couple questions. It's not like a tough interview, but you're not allowed to return to Subway and not allowed to have any contact with the listed victims.
Okay.
And so some people don't want to be on pretrial release. They prefer to just post the bond. You can do that, or you could just, if they qualify for a pretrial release, you'd be able to be released without having to post any money, okay? And you do qualify for the PD, so they'll be appointed to represent you in all 3 cases. Next case is Louis Pabon. Allegations are carrying a concealed weapon, loiter or prowling, possession less than 20 grams of cannabis, and possession of drug paraphernalia. Let's see. This, unable to verify community ties. So he does not qualify for pretrial release. So, all right, so sometimes the state makes a plea offer, sometimes they don't. Sometimes people don't even want to hear a plea offer, they'd rather just bond out of jail. Do you want to hear a plea offer, Mr. Pabon, or no?
A plea offer?
Would you like one? I don't know if they'll make one, but do you want to see? It doesn't hurt to ask. It's like going to a car and say, how much is that car? It doesn't mean you have to buy it.
Okay.
All right, state, what's the plea offer, if any?
Need one moment, Judge. Your Honor, the state's offer in this case would be an adjudication of guilt on all 4 counts, 5 days Orange County Jail, no return to the scene, court costs, cost of prosecution, Your Honor.
And then your adjudication would require him to need to revoke his driver's license for a period of 2 years, driving privilege for a period of 2 years. All right, so you don't have to take the plea offer. Take your time, think about it. You have, all right. Do you want me to pass you for a couple minutes and then let you think about it, or do you want to just?
We were discussing just the possible, some of the implications with
Yeah,
taking
go right
a
ahead.
plea.
Yeah, go ahead.
Can the state please repeat what the offer was? I apologize.
Adjudication of guilt on 4 counts, 5 days Orange County Jail, no return to the scene, court costs, cost of prosecution.
But I work at the scene.
Did Your Honor mention the conditions of release, whether they were going to be monetary, non-monetary?
He does not qualify for pretrial release, so the bond would be 500 on count 1 and then 100 on counts 2, 3, and 4.
100 each?
He's indicated he wants to accept the state's offer, Your Honor.
All right, so if you were to plead guilty or no contest to these 4 charges, each of them being misdemeanors of, counts 1, 3, and 4 misdemeanors of the first degree, punishable by up to a year in jail, and a $1,000 fine in count 2, up to 60 days in jail, you wouldn't get that. Instead, you'd be adjudicated guilty on all 4 counts. You'd be sentenced to 5 days in jail. You've already done 2. You have 3 left to go. In fact, we could tell you what your release date was. It's probably going to be Tuesday or Monday. Oh, we don't have that ability anymore? All right, maybe that's just a weekday. All right, so you've done 2 of the 5 days. The clerk would direct the DMV to revoke your driving privilege for a period of 2 years, and all the financial obligations would not be due for 1 year, and that would resolve the case here today. Mr. Pabon, is this what you want to do?
How much is the amount that I owe?
All right, so the clerk will tell us, because there's court costs and costs of prosecution. $273.
Your Honor, also just, if he does work at that address, it would be no return outside of work hours, Your Honor, if he is employed at that,
Okay.
at
I
that
agree.
location.
I agree.
All right, well, I could say that, but there wouldn't be any enforcement of it because he's not going to be on probation and it's not going to be a trespass, but
No problem.
I just don't know how to.
We can eliminate the no return condition,
Right.
Judge.
All right, so the 273 is what the total would be. Do you still want to go forward with the plea?
If that's all I gotta pay and do 3 days, yes, sir.
Well, remember, then your driver's privilege gets suspended. I don't know if you drive.
I don't drive.
All right, so, all right. And then you'd be, if someone ever says, have you ever been convicted of a misdemeanor, you'd have to say yes. And guilty means you admit it, go ahead and sentence you. No contest means you don't deny it, go ahead and sentence you. Whether you plead guilty or no contest, the sentence would be exactly the same. Not guilty means you deny the allegations. Has anyone made any promises or threats to get you to enter any type of plea here other than what's been discussed here in court?
No, sir.
Do you understand everything that's happening?
Yes, sir.
Do you understand that there would be no trial? We'd be skipping the trial and everything that happens in the trial, and we'd go right to the sentencing. Do you understand all of that?
Yes, sir.
All right, to the allegation that you committed these 4 offenses yesterday, do you plead guilty, not guilty, or no contest?
No contest.
Are you entering the no contest plea because you believe that's the best way to resolve the case for you?
No, sir, it's what I believe.
Because you believe you're guilty?
No, I'm no contest.
Okay, but are you entering the no contest plea because you believe that's the best way to resolve the case for you? Or are you entering the plea of no contest because you believe you're guilty?
I guess I'm guilty, but I only thought I had 3 charges.
You had the carrying a concealed weapon, loitering and prowling, possession of less than 20 grams of cannabis, and possession of drug paraphernalia. Those are the 4 charges. Does that change your desire to enter a plea to those 4 charges?
Well, I didn't have no possession of paraphernalia.
Okay, so you want to enter just so we're clear. You could, if you wanted to, you could enter a no contest plea to everything other than the paraphernalia, and then just bond out on the paraphernalia charge, and then you'd be able to fight that one if you wanted to.
Yes.
Okay, so but on bond, and that one would be $100.
Can I pay $100 today?
Yeah. Sure.
I'll
Okay,
get-
so this is what you want to plead to 3 of the charges, but fight the 4th.
Yes, sir.
Fair enough. All right, to the allegation that yesterday you carried a concealed weapon, loitered or prowled, possessed less than 20 grams of cannabis, do you plead guilty, not guilty, or no contest?
No contest.
Are you entering the no contest plea to those 3 charges because you believe that's the best way to resolve the case for you?
I was guilty.
Okay.
I apologize. The state and I have just discussed it, and the state's willing to drop the paraphernalia charge.
All right,
So
does that-
have him only plead to the first 3 counts. Thank you, state.
Thank you.
So then you wouldn't even have to post the $100. They were going to drop that charge. You agree with
Thank
that?
you. Thank you, sir.
All right. I'll find that you knowingly, freely, voluntarily, and intelligently have waived your constitutional rights with an understanding of the nature of the allegations and of the consequences of the plea. There's a factual basis to have accepted the plea, and I'll give you the sentence that I told you to receive. Any questions for me?
No, sir.
You have 30 days to appeal the judgment and sentence of the court. If you do so, you must do so in writing to the clerk of the court. If you can't afford an attorney, one will be appointed to represent you. All right, good luck, sir.
Yes, sir.
All right, so state orally announcing that you're dropping count 4?
Yeah, at this time, Your Honor, the state will orally no pros count 4, possession of drug paraphernalia in case number 21MM177AO, Your Honor.
If for some reason the clerk doesn't accept the no pros for the not filed charge, can we call it a no info?
Yeah, no.
I don't know.
Yes, Your Honor.
As long as it's gone. It's gone.
All announcements is good.
Okay, all announcements are good, she said. All right.
Thank you, Mr. Horn.
Just trying to help, Your Honor.
Mr. Passmore.
Yes, sir. Good evening, Your Honor.
Good evening. Yeah, you're right. You're telling me that I'm going slow today. So you're here today for the allegation of a petty theft.
Yes, sir.
It's a second-degree misdemeanor. Sometimes the state makes a plea offer. Sometimes they don't. It looks like you do not qualify for pretrial release. Whether the state makes a plea offer or not, the bond would be $250 if you don't take any plea offer, or if they don't offer one, with the condition that you don't return to the scene of the offense. State, are you able to make a plea offer on this gentleman? No return to Walgreens.
Yes, Your Honor. At this time, the state's offer is an adjudication of guilt, credit time served, no return, cost of court costs, and cost of prosecution, Your Honor.
All right, so just so we're clear about this one's a little bit more complicated. Petty theft is an enhanceable crime. The more times you commit it, the more serious it becomes. If this criminal history is correct, you at least have 1 prior petty theft. So if you have one prior, and then you have this petty theft, that means the next one would be a felony, punishable up to 5 years in prison and a $5,000 fine. Now, obviously, no one wants you to get a next one. And if you enter a plea of guilty or no contest, there's rights that you give up. There's the right to a trial, the right to make the state prove the allegations against you, the right to be represented at the trial by your lawyer, the right to subpoena witnesses to testify on your behalf, the right to testify at your trial, or the right to remain silent. If you testify, the jury would be told they have to treat your testimony the same as any other witness, and if you remain silent, the jury would be told they cannot hold it against you for exercising the right to remain silent. You qualify for the public defender's office today, so they're appointed to represent you. That's important because, once again, it's important for this reason. Some people who don't have a lawyer representing them, the state can't use the conviction to enhance the next one, but you do qualify for the PD, so they're appointed to represent you. So once again, even though the adjudication, get out of jail today on this case, not allowed to return to Walgreens and pay the financial obligations within a year, although that resolves your case and you get out. If you were to steal a stick of gum that might be 25 cents, or maybe now with inflation 50 cents, you could go to prison for 5 years, because that would be the third conviction for petty theft. Do you understand all of that?
Yes, sir.
So I'm going to give you a moment, or as much time as you need to talk to your attorney there, and then let me know whether you want to accept the plea offer or whether you want to turn it down.
Yes, Your Honor, he would like to accept the state's offer.
All right, so there's different types of pleas. There's a plea of guilty, which means you admit it, go ahead and sentence you. No contest means you don't admit it, but you don't deny it, go ahead and sentence you.
No
Whether you plead-
contest?
Yeah, hold on. Whether you plead
Oh, I'm
guilty or
sorry.
no contest, your sentence would be exactly the same, and not guilty means you deny the allegations. Do you understand the difference between the three?
Yes, sir.
Which of those three pleas do you wish to plead to this petty theft charge? Guilty, not guilty, no contest?
No contest, right?
Are you entering the no contest plea because you believe that's the best way to resolve the case for you, or because you believe you're guilty, or both?
I believe that's the best way to solve the case.
Has anyone made any promises or threats to get you to enter this plea other than what's been discussed here in open court?
No, sir.
I'll find that you knowingly, freely, voluntarily, and intelligently have waived your constitutional rights with an understanding of the nature of the allegations and the consequences of the plea. The court file establishes a factual basis to accept the plea, and I'll give you the sentence that I told you you'd receive. All right, good luck. Don't commit the next one.
Okay.
Oh, they're going to take your prints.
Thank you. All right, no more.
Yeah, adjudication, 2 days time, sir.
Correction on the gun, not him, but the one before him, I need prints for him too. He's on way down, you guys gotta call him back up. Louis Pecan? Yeah. Sorry. For him too, yeah. I'm gonna give it to you.
Hi, your name, please?
Kerwin Phillips, Your Honor. Good afternoon.
Good afternoon. All right, so the allegation is that you committed a trespass after warning. It's a misdemeanor. You have the right to hear a plea offer. Let me also find out whether or not you qualify for pretrial release, because if you do, you can at least take that into
He
consideration.
does not, Your Honor.
Does not qualify. And so, do you want to hear a plea offer, or would you prefer just to bond out of jail?
Yes, I would like to hear the plea, sir.
All right, thank
If
you.
I may.
Your Honor, the state's offer in this case is an adjudication of guilt to the trespass, credit time served, no return, court costs, cost of prosecution.
The financial obligations apparently total $273, is that right? All right, so, and you'd have 1 year to pay that, you'd be adjudicated of a felony. You then get 2 days that you've already done in jail, you'd be
Your Honor,
released.
misdemeanor, sorry, Your Honor.
You'd be adjudicated, oh, probably because I was looking at the priors. You'd be adjudicated guilty of this misdemeanor, 2 days' time served, released from custody on this case, order not to return to the location of the offense, which, let me just see how that's possible. Oh, the party liquor? And a year to pay the money. But then you'd have this criminal record again added to the rest of your criminal record. Is this what you want to do, or you want to just bond out of jail?
At this time, Your Honor, I have some medical issues that I'm dealing with. I just had surgery on my hand about 3 weeks ago, and I'm needing another surgery. And I feel personally, if I'm incarcerated, I'm unable to medically take care of myself at this present time. So I am willing to take the deal. Unfortunately, I know this is going to be added on to my criminal history as well.
Yeah, because it's, you know, some people say this is in their best interest to resolve their case. Other people, they just prefer to fight it.
Yes, sir.
It's up to you. No one makes a decision other than you, so it's up to you.
I'll go with the
You're gonna take the plea
state's
offer?
offer, please.
Do you understand the difference between guilty, not guilty, and no contest?
Yes, sir, I do.
You probably heard me talk to other people this morning about the rights they give up by entering a plea of guilty or no contest.
Yes,
Do you have
sir.
any questions about those rights?
No, sir, I don't.
Has anyone made any promises or threats to get you to enter any type of plea here today?
No, Your Honor.
To the allegation that you committed this trespass, and I think it was party liquor, let me just make sure. Party liquor, you plead guilty, not guilty, or no contest?
No contest.
Are you entering the no contest plea because you believe that's the best way to resolve the case for you?
Yes, sir.
I find that you knowingly, freely, voluntarily, and intelligently waived your constitutional rights with an understanding of the nature of the allegations and consequences of the plea, and there's a factual basis to have accepted the plea. And I'll give you the sentence that I told you to receive. Any questions?
No, sir.
All right, good luck with your hand.
Thank you very much. Thank you. Thank you.
All right, okay, we had a case, I probably shouldn't assume anything, but Dennis Ramos, bond out, not bond out?
Dennis Ramos with behavior, Your Honor.
Behavior, all right. So there's probable cause, the case will be reset for tomorrow. Is the state able to, are you here tomorrow also, or are you lucky
Yes,
just
Your
one
Honor,
day?
no, I'm here Saturday and Sunday.
All right,
So all these resets I have just on a pile right here, I'll just pick them up tomorrow.
but just so we know, this is not the case that you're gonna make an offer because it's a battery.
Yes, Your Honor, I am.
And you know, this gentleman might qualify for pretrial, oh wait, Baker Act criteria. Is he qualified for a pretrial release? We can address that tomorrow, but I'm just curious.
He was not interviewed, so if we're
Not
able to interview him, we'll talk to him.
Oh, we'll see what happens, okay.
We'll
but
have to
if-
see, sorry.
We'll see.
Oh,
Roll
I'm
till
sorry.
tomorrow.
I didn't realize you were trying to get by.
Although they're looking for him in another state, but they won't extradite him.
Yeah, Your Honor, even the victim cases where it's like Wawa or Walgreens, they say we can, you know, like.
What's that?
When it's like Wawa or Walgreens, the victim, they
Oh,
let
they,
us
all right.
put it in the pleable pile.
I know when I was doing my warrants, I don't even remember seeing an option for surrounding states only. All right, well, I guess we only, all right, so you're Andrea Sharber.
Yeah, yes.
You're wanted, wait, hold on a second. No, the next one is, you're, I was looking at the next stack for out of county. I was gonna say you're wanted for another county, but actually you're charged here with possession of drug paraphernalia. And let's see. Does she qualify for pretrial release?
No, Your Honor.
Why not?
Are you all curious about hearing a plea offer, or you want to just bond out of jail on the $500 bond?
Let's hear the plea offer.
Yeah, it doesn't hurt to hear.
Your Honor, at this time, the state's offer is an adjudication of guilt for the possession of drug paraphernalia, credit for time served, court costs, cost of prosecution.
I was looking at the wrong criminal history. This is the one that's wanted from another jurisdiction.
I was gonna say, I didn't have a hold for her. You made me nervous.
All right, so adjudication, credit time served, and the financial obligations?
Yes, Your Honor.
All right.
Who cares? I'm walking anyway.
I don't know, it's cold outside. You sure you want to do this?
I'm walking anyway.
All right.
Anybody that has speed as a vehicle.
She wants to accept, Judge.
So do you hear me explain the rights that a person gives up to when they enter a plea to the last person who was just up here?
Yes, I understand court.
All right.
Go.
You understand there won't be a trial and we'll go right to sentencing?
Yes.
You understand? You'd be and from your prior history, it looks like you might have gone through this before, as far as the plea and sentence. So,
Usually, I'm glad to have her because I know that she will speak up for me. Because I've had lawyers before where I have had to speak like Judge, do you hear my own lawyer saying to me? I've been in that situation before.
Fair enough. All right, so do you understand the difference between guilty, not guilty, no contest?
Yes, sir.
To the allegation you possess drug paraphernalia on the 8th, you plead guilty, not guilty, or no contest?
Pleading guilty, no contest.
Which means you don't admit it, but you don't deny it, you want the plea offer. Is that what you want to do?
Yes.
All right, and the no contest plea because you believe that's the best way to resolve the case for you?
Yes.
All right, I'll find that you knowingly, freely, voluntarily, and intelligently waived your constitutional rights with an understanding of the nature of the allegations and consequences of the plea, and that there's a factual basis to have accepted the plea. And I'll give you the sentence that I told you to receive. Any questions?
Time served with 6 months suspension of my license.
No, not even that bad.
Oh.
So it was because it was, yeah, drug paraphernalia. So it's a year to pay the money, no license suspension, but time served.
All right.
Very good. All right, good luck.
Thank you.
All right.
Do I just sign this?
No. All right, Mr. Carr, step on up.
All right. All right, pleasure.
So I had a blast from my past when I first started practicing law when I read your case, because they used to do this thing called bond of money or cash bond, because you probably owe $132.56 to some, to what county was that? Leon County. So probably if the 132.56 gets paid, that likely resolves the case. If I remember how they used to do this stuff. But then along came a judge in the appellate court that said that judges are not allowed to do this bond or cash bond. It can only be one thing. But I'm just curious, will all jail accept that or not? The 2,500 or
I don't have anything to
132.56?
do with the bonds, but if it was on the warrant, I assume that we will. But I don't work with the bond. I can't
What's
confirm that.
You should have 3 for me.
3 cases.
Yeah, with 132 on one, 165 for the another, and 132.
Oh, I see. So 132.78, 132, what does that say? 56? 165.49. Are you planning on trying to pay the cash bond, or you don't have cash amount, or you have to, okay, so they're just have to transport you up there and let you deal with it up there? All right. So what's gonna happen is we'll put in there this $2,500 per count, or the various money as a cash bond. Yeah. Well, it's if you see what happens is from back in the days, it means that 130 whatever, that's how much he owes per case, and the case will close. So they're like, if we get our cash money, we'll close the case. That's why it's the cash and ROR. But if they don't get their money to close the case, that's why they're saying the $2,500 per count. So just leave it the same. Yeah. I mean, that's the way they used to. That's the way they used to do it. But they're not allowed to do that. They're not allowed to issue those anymore. All right, but once you get up to Leon County, they'll pick you up, hopefully by the end of the week, and you'll be up there and be able to sort it out. Okay. All right. Good luck, sir. Gary Denmark.
Your Honor, he bonded?
Brandon Fallon. Are you Mr. Fallon? All right. So you're wanted out of another county. You're Osceola County. The bond is $250. They should pick you up in the next couple of days if you don't post the bond. If you post the bond, we'll let you out of our jail here, and then you'll get a court date from Osceola County.
Oh, okay.
Yeah. Chastity Lamb. Thank you. Miss Lamb, you're wanted out of another county, and that other county is Volusia County. So Volusia County will be told to come and pick you up. It's an add-on charge, which means you must be in our jail for some other reason. And so you'll have to resolve that other case or bond out of jail in that other case before Volusia County will be told to come and get you, okay?
I've already bonded on that.
You already did, so that's why they served this on you. So now what happens is, but Volusia County is only a couple counties away, so by administrative order, they should be picking you up by the end of the week, unless COVID has delayed that, so I don't have any control over that. But I'll appoint the public defender to represent you if you want.
Fine.
What's that?
That's fine.
Okay, I'll appoint them. Willie Miller. Let's see, are you Mr. Miller?
Yes, sir.
You're wanted out of Volusia County. There's a no bond warrant for your arrest. For some reason, the clerk believes that you don't qualify for the public defender. Let me see why. Let me ask you this. If you are in jail at no bond, do you have the ability to make money to hire a lawyer?
Right now, I don't have the money because I'm not working, but I work at the landfill for the garbage truck company. But right now, I'm in jail, so I can't make no money. I was making $90 a day. But what I was gonna ask you, if it's okay with you, I'm not trying to hold you up, if they can run my time here, because my family moved from Daytona, and all my family is staying down here in Orlando and Pine Hills.
Well, I can tell you that every day you're in our jail, you get credit towards the time served. I don't know ultimately what will happen in that case up there. There is a procedure in the law that allows cases to be moved from one circuit to another.
That's why I was asking.
But hold on, it's not about me. It's that the prosecutor in Volusia County, juvenile is very different than adult. Adult court, it requires by statute that the state attorney up there and the state attorney down here both agree to the transfer. Juvenile, it just doesn't seem like that. It's just, they just, wherever you live, they just send it. So I don't know if you've ever had it, maybe you've had friends that have been in the juvenile system that they just move it like that, but that's not how that works for adult court. Both state attorneys have to agree.
Yeah, that's why I was trying to ask you if you could put in a word for me, because I was homeless in Daytona. My family brought me down here, so I don't have no family in Daytona. If I get out in Daytona, I won't have nowhere to go. All my family's down here in Pine Hills in Orlando.
All I can do is appoint the public defender. Maybe they can work out something as far as trying to communicating to the public defender up there to try to get you a bond.
Yes,
so you can
ma'am.
bond out
Yes,
here.
sir.
That's all I could do there, is appoint the PD. If you want me to appoint them so they can try to communicate with the PD up there?
Yes, sir.
All right, good luck.
Thank you.
I'll do that. Gabriella Salomon? Hi there, let's see, we got an add-on charge, and we got 2 affidavits, 2 cases, out-of-county warrants, looks like both for VOP, well, no, what's this? VOP for Volusia County. Wow, Volusia County is gonna be coming here and picking up some people soon, because the last 3 cases are Volusia County. So the bond is no bond on these 2 cases. Do you want me to appoint the public defender to represent you?
Yes, but is there any way I can get a bond on them?
When you get to Volusia County, the judge up there can give you a bond. Because it's on a violation of probation, the IA judge doesn't have the ability to change the VOP bond.
Okay.
I mean, I don't mind you asking, but I don't have the ability to. All right, good luck. Yannick Walters. Good afternoon, sir. You're here on warrants from another jurisdiction. It looks like it was Pinellas County. Now, unlike the last couple people, you have a bond, but their bonds are kind of high. $15,000 on count 1, $5,000 on count 2, $15,000 on count 3, $5,000 on count 4. Looks like for a total of $40,000. The judge may not reduce this bond or ROR. When this was issued. Oh, this was issued in the middle of COVID. So there are times where during COVID, the judges have the ability to modify the bond amounts, but your judge said don't modify it, which means your lawyer will have to.
Can you repeat that for me, please?
What's that?
Can you repeat it for me if I get back?
Yeah. The sound quality in here isn't the best. So during this COVID situation, the judges are allowed sometimes to contact the judge assigned to the case and consider modifying bonds on non-VOP cases. And I just was reading the paperwork on the warrant, and it says the judge may not reduce this bond or ROR, which means that judge has said, don't bother calling him or her. And so I don't have the ability to change your bond amount. So they're going to contact Pinellas County. They'll pick you up, and once you get there, then you could address whether or not it can be modified. I just don't have the ability to.
And me travel to Pinellas County?
Say that again?
No, you said to travel to Pinellas County. That's what you said?
They're going, yeah.
They
pick people. When I say they corrections, they are always passing around inmates around the state. This happens all the
Yeah,
time.
'cause all my family live in Orlando now.
Yep.
And I have another question. I have sale of cocaine, possession of cocaine, and VOP. I never been on VOP for that. I mean on VOP for DUI.
I see here it says sale of cocaine, possession of cocaine, sale of cocaine, possession of cocaine. I'm not seeing a VOP. But let me just ask corrections. Are you all showing him being held on a VOP?
I I mean, we didn't run his history because he's an out-of-county, but I don't see the current charges as being a VOP. They all look like drug-related
Yeah, there's
charges.
just like 4 counts that are just sale of cocaine,
Yeah, I'm
possession,
seeing-
sale, possession.
That's what I'm seeing as well. I'm not seeing a VOP.
So we only have 2 more. No, that's impossible.
He's looking at the heading of something.
Oh, okay, got it. Oh, yeah, it's the
okay.
same charging document that they use for people. Got it.
Okay, it says stay on possession of cocaine. Okay. But I have one question though. How do they gain those? I never had those. No good caught with those. Okay.
Did he have the public defender appointed, Judge?
We can appoint the public, I think that's where we stopped. We didn't know he had a
sorry.
question. So, sir, do you want us to appoint the public defender for you?
Yeah, can I have public defender, please?
Yeah, we'll appoint. All right, good luck, sir. Next case is Matthew Donald Reynolds.
He refused, Your Honor. James.
All right, let me see here.
Your Honor, this is a back-to-back refusal, I believe.
What's that?
Did he refuse yesterday as well?
Who's that, Matthew
Reynolds?
I'm not sure, Your Honor.
He was unable to be transported, the docket says yesterday.
All right, well, let's try again on, we'll try again on Monday.
And then I guess today he refused.
We'll try again on Monday.
Third time.
But I'll, yeah. Well, I actually have a bunch more cases than I thought. I thought there was only 2, but now I just found another stack. It's like the ballots in Georgia, apparently. Jaden Stevens?
Yes, sir.
All right, thank you. All right, so your case was reset. The issue with regard to count number 1, armed burglary of a structure with a firearm. Judge Brewer had an issue. Let me take a look at the police report and review it myself and see if I can guess what the issue was.
I also have notes from the PD yesterday to explain to me what happened with this.
All right, so let me read this and then,
Sure.
go ahead. All right, I guess I don't see the word firearm at all anywhere in the police report. Is that the issue?
Yes, Judge.
Oh, that's pretty simple.
And I believe, I spoke to the state before we started. Yesterday, they were given 24 hours to cure the affidavit, and as far as I know, Mr. Horn does not have the supplemental that would cure the issue.
That's correct, Your Honor. The officer was unable to reach, was unable to get back to me on time, Judge.
So now it's just burglary of a structure instead of with a firearm.
Yes, and I believe it also takes care of count 3, the possession of firearm and commission of a felony. Oh, and carrying a concealed firearm.
1, 3, 4. Okay, so, oops, I put the sheet up here too early. All right, so it says this last, I'm looking towards your direction, but I'm really asking her. It says his last conviction was in May of 2020 for a burglary. Was it, is he on probation?
Correct.
Was that a violation of probation?
I don't have that information on the face sheet. I can run his history and try to see what he was sentenced to. Just give me 1 second, Your Honor. I have to run his criminal history again.
Thank you.
Okay, let me see.
Oh, I see. These are VOPs. Got it.
Says he was. I don't see him on DOC's website, so I don't see him as being on any supervised probation.
Thank you. All right then, so what's gonna happen is your bond on count 1 will be $5,000. Your bond on count 2 is $1,000. And then on counts 3 and counts 4, you're just gonna be ROR'd. Not allowed to possess any weapons or firearms, and you're not allowed to return back to the scene of the offense. You understand that?
Yes, sir.
All right. And you have the public defender's office representing you. Keep in contact with them. For the lesser included charge. For count 1, but not for counts 3 or 4.
I appreciate
Yeah,
it.
thank you. Kenneth Curran,
Yes, sir.
you're in custody on a no bond warrant for your arrest for a violation of probation. The clerk determined that you don't qualify for the public defender, but let me ask you a question. If you're in jail, are you still making $1,000 a week?
No, sir.
You need me to appoint the public defender to represent you?
I do, sir.
All right, I'll appoint the public defender. They'll be able to go in front of the judge assigned to the case to potentially try to get you a bond. Okay, thank you.
He also has a new law offense, Your Honor.
All right,
In
didn't see
possession
that.
of cocaine.
All right, hold on. 2 affidavits, there it is. All right, there's probable cause to believe the offense occurred and the bond is $1,000. The PD will be appointed for that case also. All right, the next case I see has got 2 cases, so thank you, sir. So they're putting on views in the VOP section, but we also had cases where it was in the felony section that was also had.
Encarnación. Ven.
I need a wheelchair.
So the, I want to make sure I'm not missing something. This is an on-view VOP and a new law violation. All right. Mr. Encarnacion, can you hear me all right?
Yes, sir.
So you have two cases here. You have a possession of a controlled substance with intent to sell, possession of cannabis with intent to sell, possession of alprazolam, and possession of greater than 20 grams of cannabis. And then the officer, when they arrested you, also did what's called an on-view violation of probation. You qualify for the public defender's office, so they'll be appointed to represent you in the case. And what I'm looking for is, they give me a sheet, your attorney has it also, the state does also, it lists like any prior criminal history. So that's what I'm looking for while I'm talking to you, even though I'm not making eye contact with you. So now I found it here. So two. So if you didn't have the VOP on the new law offense, you'd be able to be released, pretrial release.
We don't qualify people that are on state probation.
Yeah, I'm just saying that's the reason why he doesn't
Yeah,
qualify.
yeah, if he wasn't on state probation, he possibly could have been, but.
Okay. All right, so on the possession, account one, the bond, I'm gonna reduce it to $1,000. The remaining counts will each be $150. But that VOP is what's gonna hold you in custody at no bond until either your attorney goes in front of the judge assigned to the case. But don't we give the VOP dates?
He'll be seeing Judge Lambo in a couple of days.
Yeah, you'll be seeing a judge within a couple days to see if if the state's really gonna violate your probation. So, we'll find out. But right now, you're held at no bond on the VOP. I had a flashback. I used to remember them announcing in court the dates that they were being assigned.
He used to, but then the date was changed, and Judge went ahead and changed it at the last minute, and the defense was complaining.
Got it?
We're supposed to be going that day, so we don't say days, we just say
Fair enough.
7 to 10 days.
All right, thank you. Julia Vega. Good afternoon. It's a no bond warrant for your arrest for a violation of probation. The clerk determined you qualify for the public defender's office, so they'll represent you. I don't know if you were paying attention to the last person's case, but you'll be seen by a judge within the next couple days, okay? All right, thank you. Next case is Trevon Jones.
Your Honor, he bonded.
Bonded out. All right, next case, Gregory, how do you pronounce your last name, sir?
Sproul.
Sproul, all right. So the allegations are that you committed the offense of possession of an open container of alcohol. And so, are you curious about hearing a plea offer, or is it your desire to just try to bond out of jail?
Plea offer.
All right.
One moment, Your Honor, my fault.
While he's thinking about that, if you don't take whatever offer he makes, then the bond is $250, and I won't be revoking the conditions of release in the other case. So don't feel like you have to take the plea offer. But if you want to, then you'll at least be released. As to this case here, and nothing will be holding you in jail as far as I can tell. State?
Your Honor, the offer in this case is an adjudication of guilt, credit time served, with court costs and a cost of prosecution.
So adjudication of guilt, you'd be sentenced to the 2 days in jail you've done. You'd be released from jail on this case here. No, it doesn't appear that there's any other case holding you. And you'd have 1 year to pay the $273. And so it's up to you.
Yeah.
Judge, can I just have 1 second to look something up?
Yeah, go ahead.
Thank you. Judge, he wants to accept the state's offer.
Sir, do you understand the difference between the pleas of guilty and not guilty and no contest?
No contest.
But do you understand the difference between
Yes.
the three? To the allegation that you committed the offense of possession of an open container of alcohol in an area that you're not allowed to do that, which is punishable by up to 60 days in jail, do you plead guilty, not guilty, or no contest?
No contest.
Are you entering the no contest plea because you believe that's the best way to resolve the case for you, or because you believe you're guilty, or both?
I didn't understand, sir. You said it too fast.
Sure. When a person enters a plea of no contest, the court has to ask the question, are you entering the plea of no contest because you believe that's the best way to resolve the case for you? Or are you entering the plea of no contest because you believe you're guilty, or both?
I believe it's the best decision to make.
All right, I'll find that you knowingly, freely, voluntarily, and intelligently have waived your constitutional rights with an understanding of the nature of the allegations and the consequence of the plea. And I'll give you the sentence that I promise you. Any questions?
No, sir.
All right. Good luck, sir.
You're taking no action on his out on bond case.
Correct. Well, that